I may pardon, Madam.
No, we are a special bet.
Special bench.
Supplementary list, fresh submission, item number 1. Yes,
May
please.
please. The review application, my lord. Lordship allowed the case. The case was reverted from retrospective date, my lord. Lordship allowed retrospective was past, my lord. It
Correct,
was made prospective.
correct.
If it is from 2002, Lordship made it 2004, my lord.
Correct.
In 2004, I was the head clerk, not the junior accountant.
What is the position, Mr. Mudli?
Your Lordship, may kindly say what is the scope of the review? I have cited one judgment, Your Lordship can say 2013, volume 8 SC 320, paragraph 20, Your Lordship, may kindly say. Paragraph 20, 20.1 relates to when the review will be maintainable. Your Lordship, may kindly on to second point, 20.2, when the review will not be maintainable.
No, so only a mistake or error apparent on the face of the
No.
record.
Well, that was placed before the Honorable Court and being conscious of the fact that he has never joined the promotional
No, I
post.
joined.
So accordingly, his relief, that relief was not granted. Your Lordship, may kindly state it on to my counter affidavit filed in the writ petition. Internal page,
Repetition also there's a, oh, but you will not know how.
internal page 5, well, maybe it's running page 93. May I
Yes,
please-
please.
Running page 93, internal page 5 of the counter, paragraph 9.
Yes.
That in reply to the abutment.
Band. Yeah, scroll down, correct.
That in reply to the aberments made in para 6 of the writ application, it is submitted that the writ petitioner is so-and-so junior accountant was promoted to the rank of head clerk by the office order number so-and-so of the PCC of Orissa. He was placed at the disposal of conservator forest Sambalpur for posting. The conservator forest Sambalpur by his office order number so-and-so dated 12/11/2002 posted the petitioner as head clerk in the office of the divisional forest officer Rerakol division. So far as the petitioner is concerned, he has not been relieved from the Athamali Kenduli division to report for joining as head clerk at Rerakol division. Indeed, he was relieved from the duties of junior accountant with effect from 28/12/2002 in view of reversion. In view of reversion order served upon him on 28/12/2002 after finalization of the proceeding with reference to memo number so-and-so dated 26/12/2002 of the conservator forest Kotak Kendulip circle. The relief from duties of junior accountant should not be misconstrued of the fact of relief from Atmali KL division. On reversion of the petitioner from junior accountant to senior clerk, he paid time up to 2/1/2003 to give complete charge of the account section to Sri D.K. Rao senior clerk and further.
So all of this was already before the court.
Yes, yes.
Yes, and no, that was not that was not denied by filing a rejoinder. And you Lordship can see his joining report in the promotional post was
Yes.
also not accepted, and that has not been challenged. You Lordship kind on to annexure D/6, internal page 22 of the counter affidavit.
Yes.
That is letter dated 5/1/2003 of the Rerakol division.
D/6.
Yes.
You just click on annexure D/6. You scroll down, you'll get the
Internal
counter.
page
in it.
22.
Yeah, that's right.
May I place, madam?
Yes, please.
Subject, PC of Sri so-and-so, your joining report dated 3/1/2003. Since you have been reverted to the rank of senior clerk by the office order number so-and-so dated 26/12/2002 of the conservator forest KL Kotak circle, and you have not yet been relieved from the office of the DFO Atmalik division, your joining as head clerk in this office is not accepted.
Hmm.
That he has not accepted. And more so, you Lordship can say that paragraph I was placing, and you Lordship can do running page 95, internal page 7. towards bottom, you let me kindly see after F by 6, annexure F by 6. The petitioner has no letter of authority of transfer order of executive instruction or government order on the strength of which he joined at Rerakol division. Hence, it is evident that he remained absconding after handing over the charge of account section to Sri D.K. Rao senior clerk on 2/1/2003 in Atmalik division till 3/12/2004. In other words, the petitioner remained absconded from 3/1/2003 to 2/12/2004 and joined as senior clerk on 3/12/2004 at Atmalik KL division. Absconding from 3/1/2003 to 2/12/2004 is one of the charges in departmental proceeding drawn up against the petitioner by the office order number so and so dated 21/4/2006, and the reversion order was passed on 25/9/2004.
All right. Yes.
Your Lordship, my relief, I was relieved by and Your Lordship, page 44 of the writ petition, annexure 4. I was posted as head clerk, my lord. Then
You posted as head clerk.
yes, I was relieved.
You never allowed to assume charges.
Yes, my lord, that is my lord. That is on page 47, my lord.
So when you relieved only a junior.
Yes, yes, my lord, I got page 47, annexure 6. I submitted the journal report, they accepted it. And after the reversion order is set, my lord, they say it is not accepted after 2-3 days I worked in the.
No, anyway, the point is in the review petition.
Yes.
The question is this a fact which is not present
Yes,
before the
ma'am.
court? It was. So rightly or wrongly, the court has taken a decision now.
Yes.
So we leave it at that. Whatever other remedies you want to seek, you can seek. No grounds made.
Since I was head clerk on the that of, since once it is.
No, but this was all discussed both in the counter and. All right. No grounds made out for review. Review petitions dismissed. Right.
For judgment, item number 1, WA 45/2009.
In view of the discussions made in the foregoing paragraphs, since the impugned order has been passed in absence of the appellant who is a necessary party, the same is liable to be set aside on that score only. Accordingly, the order of the learned single judge dated 21st February 2008 is set aside. The writ appeal is allowed.
What is it in follow.
Number 2.
Petitioner at the villagers, they approach this honorable court for illegal lifting of the.
You
sands
file a
of the-
fresh petition, sir.
Yes,
Last 5
because-
years, this has not even come up once.
Minor.
Situation in the ground must have changed now. If the counsel of the petitioner seeks leave to withdraw this petition with liberty to file a fresh petition if the cause of action survives. Dismiss is withdrawn, liberty is granted.
Item number 3.
My lord, on behalf of the Smitaranjan Patnaik, this matter is infectious and not fresh.
All right, counsel for the petitioner states that the matter has been rendered infructuous and is accordingly not pressed. Dismiss is not pressed.
Item number 4.
My lord, the petitioner is a service provider and there was an agreement in between the OMC and the petitioner company, my lord. And in that context, Annex 4, page 115 is
But
relevant.
that agreement must be having an arbitration clause.
My lord, I have only read this, my lord. When they have agreed in by Annex 4 that paid the service tax, and accordingly I file a representation with OMC, my lord. So let my representation to be disposed of within a limited period, my lord. That purposely solved. That is only my short prayer, my lord. Annex 5 may kind of dispose of by the opposite party number 1 within a reasonable period as they have agreed by Annex 4.
This petition, which prays for a direction to the Orissa Mining Corporation to reimburse the service tax, was filed on 20th April 2018, but has not come up for hearing even once thereafter. Today, counsel for the petitioner states that he's only pressing for a limited prayer that the petitioner's representation dated 21st December 2017 to the OMC bracket Annex 5 be examined and disposed of by the OMC in a time-bound manner. Paragraph accordingly, without expressing any view on the petitioner's contentions, a direction is issued to the OMC to examine the petitioner's aforementioned representation dated 21/12/2017, and after giving the petitioner an opportunity being heard, to dispose it off in accordance with law with reasoned order, not later than 3rd January 2022. The order be made available to the petitioner not later than 10th January 2022. The petition is disposed of.
Item number 5.
This is a writ appeal matters against the order passed by the honorable single judge. Refusing to pass any interim order in my application, that was filed matters to stay the operation of the interim order by which the higher pension sanction in favor of the petitioner was withdrawn matters and direction issued matters to make overdue payment of ₹11,99,000 matters.
Where is the impugned order of the single judge?
Matters that is matters available at running page 58 matters. Honorable Chintan has issued notice of the matter and has also issued notice of the interim application matters.
Are they actually recovering from you or?
No recovery, but they have stopped the payment of the higher pension and they have seized my bank account matters. Without any notice matters, without any show cause, straight away the order was passed, withdrawing my higher pension and direction to deposit the amount matters.
No, but what is actually happening? They are not paying you pension now, is it?
No, they have started matters.
Or if we have to issue notice in this, who's
No,
accepting?
notice has been issued.
Notice and issuing the writ application matters.
Third paragraph.
But no. In the writ appeal, we have to issue notice.
Matters.
What I say is that, I know.
Who's for the state?
Now, this is employees provident fund organization matters.
So we'll have to serve them then. It's a notice by registered speed post. The tracking report will be placed on record on the next date. List on 8th December.
Problem.
Item number 6.
Same. For 5, there are 2. No, that's only a connected thing. Right. All right.
Item 6.
May it please, my lord. That in this writ appeal, the order passed by the honorable single judge
is in as challenge, my lord, on the ground that the petitioner is now aged about 71 years.
I know, for a fresh inquiry again.
My lord, not to trace inquiry, the honorable single judge come to a conclusion that since the documents were not supplied along with the memorandum of charges, I was not able to file a effective defense statement. Even though the honorable single judge convinced on that point, the matter was remanded back from the stage of supply of inquiry report.
Correct. But a time-bound direction has been issued.
Time bound, but the copy has not been given to me.
Even now,
No, till date, my lord, the, you will see page, the running page, paragraph 8, running page 26. Paragraph 8, running page 26, the impugned order.
no, that's true, but what is the date of the impugned order? 5th August.
My lord,
And they were to give you documents by, in terms of this order, by which date?
no, till date, nothing has happened.
No. The single judge must have fixed a time limit to give you documents.
My lord, I am placing my lord paragraph 8, that is clearly all the facts, the cumulative effect of the above analysis would go to show that the departmental proceeding initiated against the petitioner suffered from vice of procedural irregularities. The reasons being, while serving memorandum of charges, the petitioner was not supplied with the relevant
Come to
documents.
page 35.
My lord,
There's no time limit here.
my lord, on perusal of the above order,
The matter is remitted. Page 35 top, it says matter is remitted.
my lord, I am agreed by that remitting.
Therefore, read it, please. Therefore, please read it.
My lord, the matter is remitted back to the disciplinary authority with a direction to supply copy of the inquiry report to the petitioner, calling upon him to give effective reply in the compliance of the principles of natural justice.
Documents are not given. Okay. What is the only the report? All right. The limited grievance of the petitioner is that although the single judge held the inquiry in the resultant discipline inquiry and the resultant punishment to be bad in law on account of non-supply of documents to the appellant, in the operative portion of the impugned order, the learned single judge, while remitting the matter to the discipline authority, directed that open quotation, a copy of the inquiry report, unquote, will be supplied to for him to give an effective reply. And thereafter follow-up action will be taken. Apart from the fact that the documents were not asked to be supplied, learned counsel for the appellant states that even till now, that is more than nearly 3 months after the impugned order, even the inquiry report has not been furnished to the appellant. Notice, who will take notice? Who are the opposite parties, respondents here? Forest and Environment Department, Mr. Dilli.
All, my lord.
They have not sought the copy.
He serve a copy. Mr. Murali accepts notice for the respondents.
2 times I have copied. Last occasion also I have.
Anyway, serve him another copy. List on 21st December.
Item number 7.
Till that I am challenging that since the copy has not been given, the documents.
I'm sure they're not holding anything. They're probably not doing anything at all. So,
My lord.
so let's.
Item 7.
I have challenged the order of the single judge, my lord. Your lordship may kindly come to page 70. The order of the single judge, paragraph 4 and 5 are relevant. Before obtaining instruction through the state council and before issuing notice to the a petitioner who are the opposite parties in that case, the honorable judge passed the order directing the Tahsildar to correct ROR. The ROR has been
So
prepared.
you were
in the-
not heard at all, is it?
My lord?
You were respondent opposite party number 5, you were never heard.
No, my lord. Opposite party has not been issued notice.
But the honorable single judge has also observed that if there is no other legal impediment, if there is
No, but can't be. Without hearing them, how can you just send it back? Something in their favor is being set aside.
Well,
You see, it appears that although the present appellants were opposite parties 5, 6 and 7 in the, 5 to 11 in the writ petition. For some reason, they were not issued notice and they were not heard before the impugned order was passed by the single judge. On 5 to, you were 5 to 21, no?
Yes, ma'am.
5 to 21.
5 to 21.
Not heard by the single judge when the impugned order dated 28 September 2021 was passed. Paragraph. Notice, Mr. Das accepts notice.
we have open number 1, 2, 3.
Only 10 of you have come here.
Hello?
Only 10 of you have filed the appeal.
My lord, other petitioners are not available at present, my lord. We are the affected parties, my lord.
You have, in your constituting writ appeal, you're calling yourself petitioners. You should be appellants.
Yes, ma'am.
And they have also numbered it. Just see your constituting. You're calling yourself petitioners.
In the writ appeal, my lord.
Yes.
We are also the opposite party.
Kindly see the writ appeal constituting. What have you described yourself as?
Appellant. It to the appellant.
And they've numbered it also. No defect mark, nothing. And opposite parties, they actually should be respondents.
Yes, ma'am.
Nobody's checking. Absolutely no checking. Just make a note of this. And just see, because it's the humble petition of the petitioner. Para 1, just see para 1.
Yes, ma'am.
Petitioners are citizens of India and cause of action for filing this writ application. Then para 2, that the petitioners by filing this writ appeal.
Challenge the order.
Anything, drafting is not a problem, sir, because no judges are reading. You can just draft anything. No problem. Registry, nobody is reading. No difference between petitioner, appellant, nothing.
Sorry, my lord.
You say there are numerous errors in the cost title and in para 1 and 2, where instead of describing themselves as appellants, the appellants have been described as single quotes petitioners. The correct memo of appeal, removing all these defects, be filed before the next date. Then you say, subject to the above, notice, Mr. Das accepts notice for respondents.
Respondent 1, 2, 3.
Notice will now be issued to respondents 4, 5 and 6 by registered speed post. Additionally, through counsel who represented them before the single judge. List on 7th December.
My lord, I have filed in this case, my lord. The order should not be given effect.
Say till the next date, the impugned order shall remain stayed.
Item number 8. Review against my lord's order dated 12/8/2021.
Yes.
Short point is, my lord, may kindly take paragraph page 44.
Yes.
Starts at page 44, paragraph 7, my lord, and 7 and 8. It's true that the ROR filed under Annexure 1 discloses the petitioner as a recorded tenant of the land in question. However, it reveals the statement appended at Annexure 1 that the objection that the Tahsildar has filed an objection on 23rd March 2098 under 5A and claiming the right title and interest of land in question, and the dispute of title in the state is sub judice before the Consolidation Commissioner. that it does not, paragraph 8, it does not disclose the pendency of any litigation relating to the title, particularly when the disputed land in the ROR and so on. So be as it may, it reveals Annexure 10, basing on the reference of this one of the collector, the registered by the sub-judge, the same is stated, and the awards are pending at 60,000 some odd rupees, my lord. My lord, what has happened? What has happened, interestingly, my lord, the matter has been disposed of by the consultation commissioner in favor of the petitioner. Unfortunately, it has not been brought to the notice by the either of the government, my lord. Page 21. And that time, right,
Then this petition should have been withdrawn.
my lord.
This petition should have been withdrawn.
Yes, my lord, because unfortunately the council didn't know, because they took a stand specifically of this nature. My lord, since the matter comes up after a long time, my lord, the instructions are not there, the council.
My lord, so the writ petition itself is infructuous.
No, my lord, because now, my lord, I am the owner. It is liable to be allowed because I am the legitimate owner, and I have not been noticed under the Land Acquisition Act at any stage.
My lord, I may be permitted to submit. What my learned senior is saying, that the consultation commissioner has already disposed of the matter, declaring the right title interest in favor of the petitioner. That is by order at page 21. And the order which your lordship has passed, that the matter is pending before the consultation commission. My response submission is that what your lordship has observed in the order, that is correct. And what my learned senior is saying, that is also correct. But there is some difference. What my learned senior is placing, that is the order passed by the consultation officer. Commissioner is the revisional authority.
Yes.
Commissioner is the revisional authority. Against this order, the revision is pending before the commission. He is showing the order.
My lord, produce that.
No, that is.
They have not filed, my lord.
They have not filed a revision. Your contention is
Before the
that
commissioner.
the order passed by this honorable court, that the matter is pending before the commissioner, is not correct, because this is the order of the commissioner. And this.
No. He's saying if this is not the commissioner's order, then you would have gone in revision to the commissioner.
Yes.
Have you in fact gone in revision?
No.
That is not borne out in the record. That is why your lordship has said that you go to the section 30, because all these things can be.
If there is nothing pending before the commissioner.
That is pending. That is the affidavit in the counter affidavit. That is what observed by this honorable court.
No.
And your lordship has given.
That's what he's questioning. He says there is in fact nothing filed before the commissioner. That's what he's saying now.
Now, what I beg to.
Why did you take instructions?
Yes.
He said the short ground on which the present review petition is filed is that there was in fact no revision petition filed by the state against the order dated 28 October 2015 passed by the consolidation officer in favor of the present petitioner.
Yes.
Full stop. However, this is disputed by Mr. Mohanty, learned AGA, who states that the judgment of this court was based on the fact that the revision petition is pending before the commissioner.
Yes.
He seeks time for instructions on the details of such revision petition. At his request list on.
My lord, may I submit one thing to lordship? All that is why in the last para of the order, your lordship has given liberty to both the parties to approach the section 30 reference, because all these matters is to be decided by a pending case. A case is pending before the sub-judge. Then if he can show that.
Once his title is established, there's no need to go for 30 at all.
But that section 30 reference has to be disposed of in accordance with law. Your lordship may kindly see, when a parallel proceeding.
No, but why are we anticipating what the commissioner has done or not done? First, to find out if there is no revision petition, then a whole set of consequences flow. Correct?
Exactly.
But the proceeding under section 30, which is pending in civil court, that cannot be made infructuous by this.
We have gone on the basis there is a proceeding before the commissioner. That will become an error on the face of the record if there is no such proceeding.
The liberty, he has got, he is no way prejudiced, because he can show this to the 30 reference court. And if we can, we are unable to produce any record to show that the revision is pending, 30 reference will be answered in their favor.
No. After we notice that the revision, that court will not go against the High Court.
No, that court.
We have to anyway correct this. So anyway, we'll have to correct it to say there is no revision pending.
I will specific affidavit that whether any revision is pending.
Correct. I just frame, let them not take any action on the basis of the land acquisition proceeding in the interim.
What action will be
They
taken?
might take, intending to take possession, my lord.
Sir, possession
Is
anyway.
already taken.
After the 2013 act, they will anyway take possession.
Yes, all right. My lord is giving us a date, man.
Yes. December 6th or 7th. What is it? All right, 6th December.
Review. Item number 9. May I please your lordship. My lord, petitioner is a lessee of a black granite stone quarry, my lord. But since the date of issuance of the work order, petitioner could not able to operate the black granite stone quarry because of some nuisance in that locality has been created by some persons, my lord. Thereafter, your lordship kindly.
You given a representation.
My lord.
You given a representation on 20th April. And then 29th May, 22nd June. You've given representations.
Sorry, my lord.
You have given representations.
Yes, my lord.
You want those representations to be considered?
No, my lord. Kindly, yes, my lord. Your lordship may directed to consider the representation.
All right. The petitioner's representations.
My lord, I am appearing for the intervener. I have filed an intervention application that is allowed, my lord. And under which provision already he got.
So you will also be heard.
My lord, already he got the extension. And there was a agreement between villagers and
my lord,
government officials.
For the entire lease period of 5 years, there is no dispute that he has operated the mines. He is not making any complaint.
He enjoyed that.
Thereafter 5 months extended period, he says that 5 months, if a person could operate the mines for entire 5 years without any obstruction, for 5 months he is saying that there is obstruction, and that 5 months is already over since long. After the expiry of the lease period or extended lease period, normally your lordship never grants any, because he has to come before that. He has to no. And if your lordship is asking for disposal of the representation, then your lordship can.
There was blasting, and we villagers have objected several times, and he is illegally, there was a blasting, and that is a, my lord, I am sorry, my lord, that is in ODI in annexure in my intervention application, I have filed that is the district officials and the villagers, there is an agreement that this will not be extended, and his nominee is there. Thereafter, my lord, he has filed an representation and somehow under
before that, my
extra.
lord. Before that, my lord. Sorry.
No, this 5-month period, when did it get over?
With due apology,
August.
Over.
Since long. That is what I am saying, my lord.
No, that is over. In that period has not been operated. May I permit?
That is your allegation.
Yes. May I permit to place letters issued by the sub-collector and Tahsildar only 3 pages before your lordship? The fact behind the case is that, my lord, in that locality, some scam, some system is continuing, some store mafias are controlling the entire black granite stone quarry.
You enjoyed it for 5 years, sir. Now, why
my lord, kindly, sorry, my lord, kindly permitted to place, kindly permitted to see page 11, my lord, to place before your lordship. Page 11, my lord. That letter has issued by the Tahsildar, my lord. Kindly permitted to place. The lease of a Brusamanda black granite stone quarry number 4, pertaining to Khata number such and such, plot number such and such, with an extent of area 5 acres 600 decimil, under Tangi Tahsil is hereby granted in favor of Sri Subodh Kumar Patnaik, present petitioner, for a period of 5 months, that is 1st April 2020 to 31st 8 2021. Whenever petitioner, after receiving such letter and work order, petitioner could not able to operate the stone quarry. Thereafter, petitioner represented again and again to the Tahsildar along with the other authority concerned. Thereafter, your lordship kindly see page 36.
Maybe that extension period is already over now since 31st August.
I am not disputing that point, but has not entire royalty amount deposited, work order issued, agreement done, but could not. Kindly see page 36, my lord. Last 3 lines may I permit to place.
See, what we'll do is your representation for return of your
extension of the
if you've deposited some royalty amount, If he wants a refund because he has not operated it, that.
But that is subject to satisfaction of the competent.
Correct,
authority.
correct.
That is-
They have issued also letter to.
Only for that limited extent,
petitioner.
not for granting any extension.
Exactly.
No more extension.
Then your lordship. may
You will
carry
get
the
back
cost.
your, you'll get back, if you have not mined anything, you will get back that royalty amount that you have deposited.
Then your lordship should directly collect.
Whatever your lordship may pass order, I am ready to abide, but your lordship kindly see just a minute, my lord, page 36, my lord. What letter has issued by the Tahsildar and sub-collector? That the laborers are now in dread fear to work inside the quarry area. So he requested to take strong action against the culprits and supply of police protection to operate the quarry till end of lease period from 26 June 2021 to 31st 8 2021.
So
He
you
has
why should you put
simply
a letter
forwarded
like
the
this?
presentation.
My lord, they have issued, my
You
lord.
get relieved of the headache, you ask for refund, that's enough.
But even if it, that after also, the sub-collector issued letter to the SP Khordha to protect the present petitioner, but till yet petitioner has not been protected. So in any manner.
Yeah, now stay in peace now.
Just one line I will add, my lord. On 22nd August, 31st August his lease period is expiring. On 22nd August, he filed an FIR against some villagers that they are obstructing. So up to 22nd August, he was operating and he has a crusher unit there.
No, my lord.
That is the allegation, my lord. Plastic and crusher.
They are creating disturbance.
Directly collector, whether
The
it is-
present dispute stems from a letter issued in favor of the present petitioner by the Tahsildar Tangi, permitting him to operate the lease for an additional period of 5 months from 1st April 2021 to 31st August 2021, pertaining to the Brushabanda Blackstone Quarry number 4 in Khata number 214, plot number 554, for an area of AC 5.600 decimal. Paragraph. According to the petitioner, he has not been allowed to operate the lease. Of course, this is disputed by the interveners who claim that he was operating it till 22nd August 2021. Paragraph. Be that as it may, since the 5-month extension period was over on 31st August 2021, the limited relief that is being granted to the petitioner is only that his representation dated 22nd June 2021 and 28th June 2021 be examined by the collector.
Yes, my lord, collector Jajpur.
Collector Jajpur.
I'm sorry, Khordha.
For the, only for the purposes of determining whether any of the minimum guarantee royalty amount. What is it deposited?
Whether he has operated the mine during that period.
No, whether any refund of the royalty amount.
Royalty amount. For that extended period. But he is saying that he has
Any
got that-
refund of the royalty amount pertaining to the extended period is due to the petitioner after verifying the facts. For this purpose, a hearing will be given to the petitioner as well as to the interveners. And a reasoned order shall be passed by the collector for the not later than 10th January 2022, and copy made available to all the parties not later than 17th January 2022. The petition is disposed.
Item number 10.
Obliged, my
Petitioners house homestead land along with houses were acquired by the opposite parties for the purpose of Talcher Bimlagad new broad gauge rail project. And a compensation.
When was it acquired? Which year was it acquired?
That was acquired in the year 2015. And a compensation was paid on
No, but
21.
for enhancement of compensation, there's a procedure.
There
There is a procedure for enhancement of compensation.
in spite of representation filed by the.
Representation is not the route, sir. This acquisition took place under what? The 2013 Act?
Yes, my lord. 2013 Act.
So there is a procedure for
64 is
seeking
the-
enhancement.
Yes.
You should have availed the procedure. You say it will be open to the petitioners to avail the statutory procedures available under the 2013 Act for seeking higher compensation. Filing of representation is not the appropriate remedy. Leaving it open to the petitioners to avail of those the statutory remedies available to them in law. The petitions are disposed. All three.
Sub-item 2 and 3 are same.
Yes.
Item 11.
My lord, item 11, this is a case filed by the COVID widow who is seeking the intervention of my lord for illegal acquisition of the petitioner's homestead property in guise of a development project. Till date, there haven't been issued any notification letter or communication regarding the land acquisition.
No, when did it start? When did this land acquisition?
My lord, they have never been communicated, only under Annex
Find out,
8.
sir. You
My
have to do some homework and find out.
My lord, Annexure 8, I have done it. My lord, Annexure 8, page 48. It is only through RTI reply we could know that our land is being acquired. Annexure 8, page 48.
No, acquired meaning what? Under the 2013 Act?
My lord, 2013 Act.
So there must be a section 4, section.
No, my lord, there has been no
section
communication. My lord, there has been no communication. We have been writing to the collector office. We have
all this is in public domain.
My lord,
Land
it is not there.
notification is in public domain. Properly.
My lord, it is not
This
there.
is
That is my
relating to
case.
the SCB
It is
Medical
not there, my
College
lord.
development. Your lordship has dealt with several matters in connection with this project. His land is coming within the project area. Either we will go for acquisition or direct purchase scheme. Your lordship knows. And in case of acquisition or direct, that is a scheme provided by the policy has been framed by the government. And according to the policy, the payment will be made. If he is aggrieved, then he can go to the tribunal for enhancement. This is the procedure. And kindly see the prayer. What is the prayer? What my learned friend is submitting, that is different. But the prayer is that the district administration should provide him page 21, paragraph 2. Issue a writ of mandamus to provide the petitioner the master plan, SIA report of the SCB Medical College and Hospital development plan, proof of publication of SIA in high impact media platform, video recording of public hearing where members of affected community. What is this? He is a private individual, and how he can ask for providing all these government documents to him, and if at all he is interested to take them, let him apply under the RTI Act, whatever the
You have got something. Just see this page, Annexure 10. Some translated copy. Just see Annexure 10. It is a 2013 Act acquisition. So preliminary notification, it says, was issued on 27th January 2021.
Regarding not to my plot, my lord. It's not regarding to my plot. It's not regarding to my plot. The SIA is being conducted in individual plots, not on the project.
Then how the cause of action is there in your favor to?
My lord, Annexure 8, we only came to know that our land property is being acquired only through the RTI reply and Annexure 8.
He is anticipating this.
I'm not anticipating. My lord, page 49.
No, it only says not available. What is this?
My lord?
It only says not available.
My lord, Annexure, we have been applying in the RTI. The government departments are not declining to give us the replies and telling that it's not available.
This document which you're showing,
my lord,
which is your reply under the RTI, how does it show that your land is acquired?
My lord, Annexure 8, I'm placing Annexure 8, page 49. Serial number 4, Biplab Swine. There is the late Biplab Swine who died of COVID.
But you are Itishri Swine.
And it is, I'm Itishri Swine, is the wife of Biplab Swine. Only through RTI reply, I came to know that my land is being acquired. And they have already set the compensation amount, everything. No consent, we haven't been communicated a single piece of order.
No, you've not got this compensation.
Nothing, my lord.
Not a shred of paper.
My lord, we haven't been communicated even a document regarding this land acquisition. No consent has been taken from us. No SIA.
You have also not taken possession of your land yet. It is only according to the policy, you are entitled for this much of amount. Then we will.
My lord, they have already.
I need to confirm what the position is.
Yes, my lord.
All right. Counsel for the petitioner states that it's only through the RTI Act that they have come to learn that land and the residential house belonging to them are subject matter of acquisition for the SCB Medical College expansion project.
Yes, my lord. Expansion of SCB Medical College.
It is stated that although sums are indicated towards structural valuation and land cost, till date, no compensation has been paid. You just say notice Mr. Mohanty accepts notice for 1 to 3. 6
No,
and
Lord,
7. 1,
I
2,
think
3,
all
6
will-
and 7.
Answer.
Notice be issued to 4 and 5 by registered speed post. Tracking report be placed on record. Till the next date of hearing, status quo be maintained as regards the.
My lord, the work is going on because any day.
No, you either pay them compensation.
No, without payment, we will not touch their land.
Then that's why we're saying status quo. They are saying they are not being paid anything.
No, your lordship may kindly see, we have not taken possession of his land.
Then there's a question that status quo be maintained till
Because
you
we cannot
confirm
proceed-
whether you are paying.
We cannot
compensation.
proceed with the project work. If
Not the entire project, on their property.
On the plot number 113/7.
Yeah, status quo.
Then
as
your
regards
lordship
the
may
petitioner's plot.
It's a very short date. Within 7 days, I will.
Yes, yes.
File within next week, I will file the count.
All right, no problem. You say status quo be maintained as regards plot number 113/721 in Khata number 12 over an area of 0.063 acre in Moza Mangalabag, Unit 20 Cuttack. Reply be filed within 2 weeks, rejoined for the next date.
My lord,
29th November.
next week I will file it. By Monday, I will file the count.
Okay, 22nd November. All right,
22nd.
November. November is not even less than a month we're giving you. It's okay. It's all right.
Item number 12.
May I please, your lordship. My lord, the land of the petitioner was acquired without payment of the compulsory amount, and earlier this honorable court had given liberty to furnish better particulars. Then I filed an application by Annexure 4 before the executive engineer whether the lands have been acquired or not, and whether payment has been made or not. Kindly see the answer to that Annexure 6. Annexure 6, page 43. In enclosing herewith the xerox of the application of Sri Durga Prasad Parida at Mallipur and Bindharpur, Jajpur, so I am requesting you to furnish the required information, non-payment of the compensation amount for acquisition of the lands for construction of the approach road of HL Bridge over River Kani and Kusumi in the district of Chandrapada to the undersigned within 7 days for further action which are not available in the division. Then next
As a name figure in any award, land acquisition award.
No, they have not made the award. Kindly see page 7. Page 7 may kindly see. Page 7, page 44. Sorry, Annexure 7, page 44. With reference to the subject cited above, it is informed that no compensation had been paid by this office for acquisition of the land for a construction of the approach road of HL Bridge over Kani Kusumi in the district of Chandrapada. They have admitted that they have not paid the amount.
No, look at the prayer in your writ petition.
Yes, madam.
You asking for a mandamus to be issued to acquire the scheduled properties.
Yes, because they are not illegally acquired. They are not illegally acquired property, but they have forcibly they have taken the possession of the land.
No, that cannot be, Mr. Jana. Then how do you know that the possession of your land has been taken?
Because in my letter also I had given the particulars of my land, which have been to the executive engineer in my annexure 4 manner. Annexure 4 I have specifically given which lands have been acquired.
When did all this happen, Mr. Jana? When was this bridge constructed?
Yes.
Which year was it constructed?
The bridge has been constructed.
No dates are given.
Okay. Just come.
There is no something to show that his land.
You'll have to first of all tell us when was this road or bridge, when was it constructed?
Then I may be allowed to give amendment petition because I have to obtain the matter from the office itself. Because
At the request of Mr. Jana, list after 4 weeks.
Item 13.
May I pray for next week, my lord? Item 13.
Or at the request of Mr. Sahni. Learned counsel for the. Mr. Pradhan. Sorry, Mr. Pradhan. Pradhan, learned counsel for the petitioner. List after 4 weeks. All right.
Item number 14.
My lord,
Alternative arrangements.
On behalf of my learned senior and late Damodarpati,
Right.
was expired on 25th
Correct,
of this
correct,
month.
correct. You see,
And being the junior, I am trying my lordship
all right, all
to
right.
convince this.
Okay.
And in this case, the petitioner challenging the notice dated 30th June 2021, issued under section 148 of the IT Act, which is barred by limitation.
So there is already a similar order, I think.
Yes, my lord, I am appearing, my lord, on behalf of the opposite participant.
All right, notice.
Yes, I have filed the order copy.
Similar orders, all right. Mr. Mahapatra accepts notice, same order.
Yes.
In both matters?
Both matters.
Yes.
All right, all right,
Obliged.
all right.
Item 15.
May I please, your lords, the petitioner before my lords by challenging the notice under section 148 of the IT Act under annexure 2 issued on dated 25.
All right, same order. These two also same order.
Yes, my lord, same order.
Same order. Mr. Mahapatra accepts notice. All right. Which date is that? 24th January?
24 January.
Right, right.
But extra copy is short.
Yes, yes.
Published.
Action meanwhile.
All
No
right.
action against that notice. ma'am.
That's already there in the order. Yes.
Item 16.
Please allow. But this is again another matter regarding that standoff regarding the commercial.
Yesterday
court,
also.
and your
Correct,
lordships have already passed certain orders.
Correct. Similar order.
So only the numbers have to be changed as far as the case is.
All right. When are they listed now?
31st of January 2020.
All right.
Same date, all the
Yes,
matters can be heard together so that the
Correct.
entire issue can be settled.
Correct.
Because all the matters are now getting stacked up before the different commission.
Right, right. Okay.
Obliged.
Right.
Item 17.
Please, your lordship. My lord, homestead land of the petitioner was taken in acquisition under the Coal Bearing Act, but compensation was paid on the basis of agricultural land. And further, the trees, several mango trees are standing, that was not taken into account. My lord, the petitioner.
When did all this happen, sir?
My lord, the petitioner received compensation on 3/4/2021 and on protest, my lord, by the annexure 5.
But
And
if you
thereafter,
want enhanced compensation, then what is the provision for that?
my lord, my
There is no
land
provision
is
for
agricultural.
seeking reference, correct?
My lord,
So why don't you go in a reference?
my lord, I have filed application by the annexure 6 that was not taken into consideration.
What is this application?
My lord, annexure 6, my lord, I have in the application I have prayed that the my land is a homestead land, but compensation has been paid treating as malasadhana. That is,
You have to file a reference petition, sir.
my lord,
Not representation. You have to seek a reference to the court for enhancement of compensation.
my lord, further trees, several trees, mango trees standing on my land.
Sir,
That
are
was
you
also
able
not
to hear me? Are you able to hear me?
my lord, my lord,
Are you able to understand the question?
my lord. You are,
What is the question, sir? What is the question?
my lord, to seek reference, my lord,
Have you sought reference?
my lord.
What does my lord mean?
My lord, under section
Yes or no?
64,
Have you sought reference?
my lord.
ଆପଣ reference କରିଛନ୍ତି?
My lord, I have given application by the annexure 6 to the land acquisition officer.
That is not application, sir. That is not an application. You don't know the difference between application and representation. This is the whole problem.
My lord, I have not filed the reference.
Kindly do that, sir. There is already a part-time tribunal under the Coal Bearing Act for adjudicating cases. This has been set up by the Government of India by a letter dated 28 January 2021. All right.
My lord.
You say there is a part-time tribunal under section 14 bracket 2 of the Coal Bearing Act. Coal Bearing Areas Acquisition Development Act 1957 at Jharsuguda for adjudicating cases arising out of the dispute of payment of compensation to be made to persons whose lands have been acquired under the said act in the districts of Jharsuguda and Sundargarh. Full stop. It will be open to the present petitioner to avail of that remedy by filing an appropriate application before the said tribunal in accordance with law. The petitions are accordingly disposed of. Why don't you send him by WhatsApp this letter? Mr. Das will send you this letter by WhatsApp. Yes.
Item 18.
May I please, my lord? My lord, this is a matter, my lord, which one such matter got listed yesterday also, my lord.
Correct.
And my lord, the next date of hearing in main writ petition, my lord, 24499 of 2020 is 16th of November 2021.
All right.
The only thing is, my lord, yesterday in the order, my lord, though it is stated, this today's petition also mentioned, it is stated list on 16th November along with WPC 32166 of 2021, which is today before my lord. But my lord, as such, no formal notice was issued, my lord.
All right, because it's
in the first petition notices have been
issued notice in this notice. Mr. Mudali accepts notice.
No, here your lordship may kindly say, no, there is no.
This is GST.
Yes, no.
Yes, my lord, I am appearing.
This is GST.
All right.
So far as opposite party number 2 is concerned,
you have no role.
No, there is no such department in the state of Orissa. Department of Revenue, there is no such department.
Finance department. It's all right. Mr. Mudali accepts notice on behalf of the finance department.
Extra copy may kindly serve, my lord.
Mr. Chimanka accepts on behalf of Mr. Chimanka, you are on behalf of 6. Opposite party number 6.
Yes, my lord.
All right.
My lord, extra copy may kindly serve, my lord.
Yes. List on 16 November. All right.
My lord would consider issuing notice in yesterday's petition also, my lord.
Not today. We'll do that.
All right. Otherwise, my lord, in the main petition, counter rejoinder have been filed.
That's right.
That we'll argue on the next date.
Yes.
Cost title of the opposite part number 2 be corrected accordingly.
Yes, that will.
Yes, the amended cost title. Yeah. All right.
Deeply obliged.
All right.
Item 19.
My lord, extra copy may kindly serve, my lord.
Yes, it will have. We'll solve. Yes.
May please last amendment. Yes, the petitioner prays for to closure of the foreign liquor on shop with bar, foreign liquor off shop and consummate liquor shop in the Rouse Patana, which is a high density area, and a number of school, colleges and medical clinics are there, my lord. But the within a 50-meter radius, my lord.
All right, your representations are there. They will consider your representation. If the petitioner's representations bracket annexure 2 shall be examined by the
Excise Commissioner.
Bracket opposite party number 3. After
After
issuing
hearing
notice
the
to both the
petitioners
petitioners
and
as well
opposite
as
party number
opposite party number
4
4,
to
5
6.
and 6. And after giving all the parties a hearing, a reasoned order shall be passed.
My lord, may kindly give some more time because there are so many representations.
1st February, all right. Not later than 1st February 2022. And the order be made available to the parties not later than 8th February 2022. The court clarifies it has not expressed any view on the contentions of the petition.
My lord, the petitioners will produce the order copy for compliance.
Downloaded copy of this order be produced before the Excise Commissioner by the petitioners not later than 15th November 2021 for compliance. Right.
Obliged.
Item 20.
May I please, your lordship? My lord, item 20.
Yes.
May I please, your lordship? Here I have challenged the very proceeding imposing, my lord, royalty and penalty on me on the ground of being without jurisdiction and wrong application of the provision, and also without providing opportunity of hearing. Now here they found that some 500 cubic meter of stone, which has been subsequently mentioned as 400 cubic meter of stone, was stacked at the crusher unit of the petitioner, which is defunct since last 3 years. A report was made under Annexure 1 at page 8 by the Revenue inspector regarding this stacking.
This must be an appealable order.
Yes,
Mr.
my lord.
Mishra.
No, I'll just clarify. This is an appellable order. Why I have come before your lordship? That is what I have said, my lord. That it is an appellable order. Why I have come? By virtue of application of here, your lordship will kindly see. Only I beg to point out one thing to your lordship. That is by application of Rule 2016 they have applied. Rule 2016 is with regard to royalty while removing minerals from the authorized place. That is your lordship will kindly find. Place 51 is with regard to penalties and other things. Rule 25 of Rule 2016 is with regard to royalty. Here is a case where their case is based on the premises that it is illegal storage. And storage nowhere is provided so far as this Rule 2016 is concerned. It is provided in Rule 2007, that is Orissa Mineral Prevention of Theft, Smuggling and Illegal Mining. And
Those are all grounds for your
Yes,
appeal.
my lord. Yes, my lord.
Those are the grounds for your appeal, Mr. Mishra.
My lord, only difficulty would be the appeal is onerous. So far as the appeal under Rule 2016.
We'll have a time-bound direction. You tell us when you are filing the appeal, we'll ask him to dispose it off in a time-bound manner.
But the only difficulty is with regard to deposit that is provided in Rule 46.
This is 1,95,000. How much will be the deposit?
Had it been under the Rule 2007, your lordship will find the fine is only up to 25,000 and confiscation, and the appeal is also not onerous and doesn't provide any condition. Whereas Rule 46 provides for a condition. That is why I am before your lordship.
No, what is the
condition? Prepayment, that is pre-deposit.
Pre-deposit condition is there. Which had the correct provision been applied by the
appellate authority, maximum 25% or 50% they are imposing. So it is only 1,95,000. So if he owned the case, appeal, it will be refunded to him.
Correct. You say counsel for the appellant petitioner seeks leave to withdraw the petition with liberty to file the appeal against the impugned order, subject to the court giving directions for time-bound disposal of the said appeal. Accordingly, it is directed that if the petitioner files an appeal not later than 15th November 2021, along with an application, what is the delay? Will there be a delay?
Yes, my lord. It is an order of 2020. The impugned order passed by the Tahsildar is of the year 2020. So there is a delay. He will file a petition for condonation of delay. That will be liberally viewed by the
Tahsildar's order is 20.
No, but when I received the notice at page 10 on 16/9/2021, I got the copies and then filed this writ petition, my lord. But that was passed in my absence.
All right.
That can
along
be
with an
found for
application for
condonation.
condonation of delay, if any, explaining that the delay is on account of the pendency of the present and accounting for the period during which the pendency present petition is pending. Such appeal will be considered on its merits along with the application for delay, and a reasoned order should be passed with the appellate authority not later than 1st February 2021. And the order be made available to the petitioner not later than 8th February 2021. The court clarifies it has not expressed any view on merits. The petition is disposed of as withdrawn in the above terms.
Obliged. Item 21.
Yes, yesterday also this came up.
Item number 21.
My lord, may it please your lordship, your lordship.
Yes,
my lord, my lord, may it please your lordship.
Yes.
My lord, item 21, there are 5 appeals. Your lordship may kindly, first is WA number 293 by 2011. Your lordship may kindly permit me to place the order dated 21/8/2012.
Yes.
My lord. The first part of the order says, heard issue notice to respondents by registered post with ID on admission in view of the judgment of Apex Court in Shivasakti Cooperative Housing Society, Nagpur versus Messrs. Swaraj Developers and others, 2003 1 OLR SC 673. Then after the interim order has been granted. The fact of the case, only so far the point of law is concerned, your lordship, that the appellant is the plaintiff.
Correct. You've got your own suit state like this.
My lord.
Only a 711 was sent back for a fresh disposal.
My lord, I am placing it, your lordship. My lord, appellant is the plaintiff, your lordship.
Correct.
The respondent here is
711
respondent, the defendant filed a 711 petition.
Correct.
That petition was rejected.
Correct.
Now, if that petition is rejected, in view of this observation, the judgment passed by the Honorable Apex Court, it is a revisable order, Your Lordship. That is the point of law on which Your Lordship has been pleased to admit the appeal. My Lord has been pleased to, if Your Lordship will permit me to place.
So the impugned order of the single judge is in a writ petition, not in a revision petition. Correct?
My Lord, my prayer is that revision.
So what difference? Suppose in a revision petition the same order had been passed, what would be the result?
My Lord, that I would have challenged. The question.
You have challenged it here.
My Lord, the difficulty
is what? For the last 10 years, your suit has not moved an inch. How
My
does
Lord,
it help you?
I have no objection if Your Lordship send back the matter again for consideration. The question is.
You are delaying your own suit unnecessarily like this.
My Lord,
I fail to understand this. Instead of your suit moving forward, you are getting it stuck like this.
My Lord, the reason is that Your Lordship may kindly see the order passed by Honorable Single Judge.
You wanted a declaration that some say deed is fraudulent, correct?
My Lord.
So how are you going any inch towards that destination?
The difficulty is that Your Lordship.
Further and further away.
My Lord, my difficulty is.
You'll get more third-party interest created like this.
Your Lordship may kindly, my prayer is that, Your Lordship, the Honorable Single Judge has been pleased to pass in the writ an entire order. It is not a simple.
Sir, this is a bad advice to whoever the appellant is, not telling him that if he wants his suit to be disposed of, this is the wrong route to take. Your suit will never be heard now for the next 10 years like this.
Your Lordship may kindly permit me only one line to submit, Your Lordship. The Honorable Single Judge has been pleased to pass an order entirely discussing the matter that the suit is to be valued in a particular way. The fraudulent sell deed, which I have never signed, which I have never presented, the valuation is 6,60,000. But I have filed a declaration suit making my own valuation of 2,500.
End of the day, it has the 711 itself has been sent back for a fresh disposal, correct?
That may be considered without observation.
This you should have said on the first day, instead of keeping this writ appeal pending for 10 years.
My Lord, the point is that because Order 7 Rule 11 petition, they have challenged in the writ, and Your Lordship has said by order dated 21/8/2012 that it is a revisable order. That Your Lordship has also observed. Because the
difference, net result is the 711 is going for a fresh consideration, correct?
That may be considered without being influenced by the.
We'll say that.
Yes, Your Lordship. Without being influenced by the observations made in the orders.
All right, sir. You say by the impugned order dated 23rd March 2011. The learned in writ petition civil 20637 of 2010, the learned single judge has remanded the application filed by the defendant public respondent herein under Order 7 Rule 11 CPC read with section 151 thereof for a fresh consideration by the trial court. Paragraph. It is clarified that none of the observations or merits made in the impugned order will affect the fresh determination of such application by the trial court. In other words, the trial court will decide the Order 7 to 11 application independent of any observations made in the impugned order by the single judge. Considering that the suit has been pending for a long time, the trial court, that is the civil judge junior division, is requested to dispose of the Order 7 Rule 11 application within a period of 6 months from the date of production of this order. Certified copy of this order before the said judge by the present appellant. The appeals are disposed of in the above terms. All the connected matters are the same.
Same, my lord.
All right. All right. The first page of the 293 of 2011 be reconstructed by the office.
Item 22.
22, here the writ petition has been filed on the basis of an of a ROR issued in the year 1979. So I pray your lordship may grant some time to file the counter affidavit.
It's a 2017 matter, sir.
Yes, ma'am.
Now what counter? You should simply produce a record.
I have filed a petition for intervention here. I have filed a petition before the NGT where the respondents have filed a affidavit that the matter relating to this is pending before this honorable court. The prayer is completely different and delaying the matter there. Your lordship may see my petition where I have quoted my prayer in para 2.
The copy has not been served.
May I pray, my lord, I am for the petition. Let it be transferred to the NGT, my lord.
He is also agreeing it can go to the NGT.
Your lordship may transfer it.
Not transfer, you just file a fresh petition to the NGT.
With the liberty.
Yes. Counsel, the petitioner seeks leave to withdraw this petition with liberty to approach the National Green Tribunal.
And contempt application is pending, madam.
In accordance with law. The petition is disposed of as withdrawn in the above terms.
Obliged.
You say in view of the order passed today in this writ petition, this contempt petition is closed.
Thank you. Obliged, ma'am.
Item 23.
Before.
My lord, I beg pardon, my lord. It will be taken up 10th. My friend's application is
16th, I thought, 10th or 16th? 10th, same date, same date, 10th.
Item 24. Item number 24.
24 a batch of cases are there challenging same judgment. In the first case, I am the respondent.
Right.
In the second case, I am the appellant and some other cases are also connected.
All
If you
right.
will call it some other day so that it can be hard also disposed of.
In this case, my lord, I am the respondent number 5 to 10 in the appellant.
Right.
In the writ of bill.
Right.
Number 72 and 156 and also 152. In this case, the appellants are taking several times.
No, he is ready. Mr. Rautre says it can be heard today.
So far as my case is concerned, I am the respondent in the first case. I think Mr. Sharma is there also. He's another case as the appellant. In another case, I am appellant, but in the first case, interim order has been passed by Mr. Mishra. Mr. KP Mishra was arguing that matter.
You are Mr. Prasanna Kumar Mishra.
No, I am Prasanna Kumar Mishra, but Mr. KP Mishra, my lord, senior Mr. KP Mishra has been engaged in this case to argue on behalf of the appellant.
Where is he?
Lord, he was.
You have to speak in the mic, sir.
He was to
kindly speak into the mic.
He was to come on my lord VC, but my lord probably is not getting the link, my lord.
So we'll pass it over anyway. Mr. Rautre will pass it over.
Can it bring up some other day also? Because I have
No, he is opposing this adjournment.
Yes, in this case, my lord, after getting the single bench order, opposite part number 2 of a writ petition, collector has disengaged the petitioner, disengaged the appointee. Thereafter, this order, this disengagement order has been challenged.
The question for consideration in this case that whether to a contractual appointee the reservation principle will be applicable or not. Basis on which, because there is a far-reaching consequence. There was an act in 1975, so far as the Orissa state is concerned. But subsequently, in view of the judgment Indra Sahni's case in 93 Supreme Court and Nagarajan other cases, now the contractual appointment rule 2013, which has been made by the state itself, and the basis on which the promotion has been given, on which appointment has been given, contractual appointment, there is a specific provision for reservations. Nobody challenges the very provision of reservation in the contractual appointment rule or in the rule itself. That rule also includes that rule where it has been provided for reservation. Reservation has to be followed. The entire case of the respondent, who was the petition before the Honorable Single Judge, that reservation, because 75 Act says that will not be applicable to contractual appointee. Therefore, all contractual appointment which have been made, and all these appointments have been made long since, in terms of the rule 2013 and rule 2010. And they have been given promotion. And all appointment has to now go. That if the ultimate conclusion of the single judge is accepted, relying upon that 75 Act, where there is a provision that it will not be applicable, reservation will not be applicable to contractual appointment. But subsequent rules which have been framed by the state, all appointment, insofar the Orissa is concerned, group B, C, and D, appointment has to be made on contractual basis, for which a statutory rule has been framed. One rule also must have come across 2013 rule. And so far as this case is concerned, the respondents who have got appointment and promotion in the meantime for last 10 years, they have appointed after following the reservation policy in terms of the rule which was in governing the field in 2013. So in fact, the state has taken all stand throughout, but somehow state has not filed any appeal. That is the problem. But this is the question for consideration with your lordship.
Who's for the state in this?
I'm appealing to the state, your lordship.
All right. All right.
My lord, single bench hold that Angarwadi supervisor is the contractual appointment. In the contractual appointment, section 380 of Waribag will not applicable. I am citing the judgment of this court for your lordship's perusal. Your lordship hold that in WN number 86 by 2018, para 29 and 30. Kindly see para 29 and 30. In contractual appointment,
better if your lordship will fix up another date so that you can give a note of submission to your lordships with all reference of the judgment and the rules which has been framed from time to time and the constitutional bench judgment so far as the reservation is concerned. Then your lordship, it will be better. There's a far-reaching consequence. All appointments are made on contractual basis nowadays.
All right. The Mr. V.C. Mishra, London Senior Counsel. Who's that?
P. Mishra.
P. Mishra? No. He's supposed to appear. He's not.
Kali Prasanna Mishra. He is.
Mr. K.P. Mishra, London Senior Counsel, appearing for the appellant, is unable to join on virtual link today. List for final hearing, all the matters. On 11 January 2022.
Yes, interim order to continue.
Interim order to continue.
25.
May I please, your lordship? May I please, your lordship?
Yes, please.
Yes, my lord. My lord, here in this case, the land particulars which I have given, my lord, under Annex 1 series, these are all, my lord, government lands for the purpose of benefit of the people, reserved for the benefit of the people, that is pond, my lord, embankment of the pond, also, my lord, burial ground, and also for Gramya jungle, roads, etc., my lord. These are all for public purposes for the use of public, my lord. What the opposite party number 2, my lord, Orissa Industrial Infrastructure Development Corporation, represented through its managing director, IDCO, my lord, he, my lord, illegally encroached these lands of the villagers. Those were being used by the villagers since time immemorial, my lord, since their forefathers. And right now, he has made, my lord, a stone boundary wall throughout the entire 200 some acres of land, my lord, and uprooted some valuable trees which have been reserved for the purpose of the village people, my lord. They were maintaining their livelihood from that jungle, my lord. That has already been uprooted. And very few, my lord, trees are still alive, my lord. Otherwise, other jungles that has been uprooted. And right now, the burial ground and the road that has been covered by, entirely covered by the Industrial Development Corporation. In spite of our objection, my lord, no action has been taken by the Tahsildar, even the collector also. My lord, we the villagers have repeatedly approached.
PL petitioner.
My lord, yes, this is a PL petition, my lord. I have filed this application in the nature of PIL. Your lordship may kindly take action against the. My lord, I have given. And my lord, apart from this, my lord, I would like to show Annex 3, my lord, page 29, your lordship may kindly come. Under RTI Act, we have, my lord, seek information from the concerned authority under which, my lord, provision, my lord, this land has been given to IDCO. And your lordship may kindly see, my lord, page 29, information schedule, my lord, your lordship may kindly see. The question of handing over the above land by the Kaju Corporation to IDCO does not arise. My lord, this land has not been given at any point of time to IDCO. Right now, IDCO is proceeding with the construction work and he has already surrounded the.
You may seem to have made representations.
My lord, I have made, my lord, several representations under Annex 5 series to the collector, to the Tahsildar. My lord, repeatedly since 2018, my lord, representations have been filed on consecutive occasions.
Who's appearing in this?
My lord, IDCO and so far as IDCO and Odisha Kaju, Odisha State Cashew Development Corporation is concerned, my lord, notice is to go. But the rest of the opposite party, I can take notice.
No, but it's only about considering the representation. The representation is made to the State Cashew Development Corporation or IDCO?
To the Tahsildar, to the collector.
And so the collector call all the parties in here.
My lord.
The petitioner's representations dated 27th March 2018.
Then, my lord,
and 22nd October 2020 shall be considered.
13/3/2018 also.
Yeah.
My lord, 13/3/2018.
And after hearing the petitioners as well as the opposite parties, 1 and 2 is it. A reasoned order shall be passed by the Collector Khurda not later than 8th February 2022 can be communicated to the parties not later than 15 February 20. The court clarifies it has not expressed any view on the merits of the petitioner's contentions.
My lord, I have filed interim application also, my lord. On each and every day, my lord, they are with bulldozers and other
It will be
materials.
open to the petitioners to approach the collector for appropriate interim reliefs. Yes.
Item 26.
Obligation.
Please, Lord. Item 26. The petitioner does not want to proceed with the case. Kindly permit it to withdraw.
Permit them to withdraw it. All right.
Item. Item 27.
My lords, I am for the petitioner.
Yes.
My lords, we had filed this petition challenging the refund denial to us on the ground that the provisions of 89(5)
Department is to file counter
are ultra virus. Sir, we had challenged the constitutional validity of that rule.
No, notice has been issued last time.
Yes, sir. Yes, sir.
SLPs were pending in the Supreme Court.
That SLP has been decided against us, my lords. Therefore, we crave leave to withdraw this petition.
Okay.
That is, we have filed this IA with only, my lords, if my lord may permit, only with one small consequential relief.
Yes.
Filed the refund claims, my lords. We were required to reverse the input tax credit, whatever refund we are filing, through our electronic credit ledger. So, sir, once the refund claim is denied to us, the law requires the department to restore our credit ledger by the same amount which was debited earlier. So my only humble prayer, my lord, before my lords, is that direction may be given to the party to allow the restoration of that credit in accordance with law. That is the only prayer. Allow me to withdraw the petition with this small prayer.
Yes, who's for the GS?
Mr. We have to file counter, my lord.
No,
Yes,
no,
my
he's
lord.
withdrawing the writ petition. Where's the Mr. Counter?
Then the prayer may kindly be considered as IA, opposite part number 5, my lord. To Deputy Commissioner, State Tax, Central Tax and GST, Circle Department, my lord.
I am appearing for opinion number 4 and 5. What my friend has submitted that while withdrawing that liberty, that I'll check up, my lord, whether
He will, no, we're not expressing any view. He will just make an application, you deal with it.
yes, in the light of the recent.
Yeah. Counsel for the petitioner states that in view of the judgments of the Supreme Court, the present application has been filed seeking withdrawal of the writ petition, but with this prayer that they may be permitted, petitioners may be permitted to apply to the opposite party number 5, that is Deputy Commissioners, State Tax, Central Tax and GST, Circle Bar Bill, to allow the recredit of the input tax credit amount sought as cash refund to the electronic credit ledger of the petitioner by issuing an appropriate order in PMT 03 in terms of rules 86(4) of the CGST(OGST) rules. Paragraph. The application is disposed of by allowing the petitioner to withdraw the petition and further permitting the petitioner to make a plea to opposite party number 5 in the above terms in accordance with law. If such a plea is made, the opposite party number 5 will examine it and pass appropriate orders not later than 8 weeks thereafter. The writ petition is disposed of as withdrawn in the above terms. Right.
Please, that if the time may be slightly reduced because we need to file a return and utilize that credit. If the time may be reduced by to 4 or 6 weeks, my lords.
It's okay. 8 weeks and 6 weeks, it doesn't make a difference. Yes.
28.
There are some defects. I made some time, 3-4 days time to remove the defects.
All right. List after removal of defects.
29.
this case, Millard, some defects has been shown by the
Right.
staff.
Yeah, list after removal of defects. All right.
Item 30.
Same, list after removal of defects.
No, my lord, I have already removed the all sorts of defects, my lord. My lord, including the defect number 22 also that will be removed because we have given the representation on 19/8/2021, and in the meantime 2 months has already passed, and I filed the representation before the government stating there that the poor persons, those who have engaged for a craft workers, laborers, and so also the tent laborers, they should be given the compensation, or not the compensation, but the financial assistance, because due to the promulgation of
all this is a matter of policy, sir. We can't issue a mandamus for these things.
And these.
This is a matter of policy, please.
No, my lord, this is the thing, my lord. Earlier, number of cases I had filed before this honorable court, and after interference of this court, my lord, the state government has given several assistance to the persons, my lord. There was no financial assistance to the advocates, my lord. I filed the case before this honorable court, and after interference of this honorable court, my lord, the 10,000 advocates of the Orissa, they received 5,000 each, only for the interference of this honorable court, my lord. And if my lord will not interfere in this case, my lord, the laborers, they will die, my lord. Because
don't keep arguing like this, please. These are all matters for policy. You know the scope of interference.
No, we have given the representation. They should take the decision, my lord.
Yes.
They should take the decision at least.
Yes.
And saying that this is the defect, there 60 days has not been passed, the matter will not be taken up, my lord, in this manner. The time has
You
already
first
passed.
convince the registry. You first remove all the defects. You say list after removal of defects.
No, we have removed all the defects, my lord.
We're not entering into an argument here on that. The registry has indicated to us the defects are not removed. You please remove it. Yes.
My lord, may kindly see one thing, my lord. My lord, so far the all sorts of defects are there. I requested the ADR that these defects that can be removed, and accordingly I filed the press baklatnama, including the enrollment numbers of the advocates and so also telephone number of the advocates, and that they have not taken into consideration. That's why I filed before this, my lord, and all the sorts of defects I have already removed, my lord. And as per the direction of the my lord, my lord, 2 months is required for filing of the listing of the case, my lord, and already 2 months has already been passed, my lord. But that has not been considered.
All right.
Well, item 31.
Well, item 31, my lord, the one with the defect will be removed.
All right. List after removal.
Item 32.
May I please, your lordship. My lord, item number 32, IA has been filed for change of nomenclature. Inadvertently, we had filed WPC instead of WPCRL.
All right. You say that IA is taken on board. The writ petition is treated as WPCRL.
Yes, sir.
Now it will go before the roster bench. What's the prayer here?
Prayer, lordship, sir, habeas corpus case in which missing girl the product.
All right. Notice, Mr. Katke accepts notice.
The major girl must just I'm bringing to lordship's kind notice. The girl as well as the accused both belong to the same village, and the boy is of a lower caste. That is the reason why there is quarrel between both the families. And in the meantime, the petition father has posted in the Facebook the photograph that shows that both are married. In the meantime, both are staying somewhere in Kolkata. In the meantime, they have switched off their mobile phones.
Lordship, we have not received any information regarding it.
Get your instruction about the girl.
Married.
You filed the status report. The status report will be filed before the next date.
Yes.
List on 11th November.
Item 33.
Item 33 is a second round of litigation. While order dated 17/3/2021, my lord had directed the collector Sundargarh to conduct an inquiry within the affected areas with prior notice to the villages.
There's some defect not removed, it says.
My lord, only the phone number I have not missed to. Phone number.
All right. What is the prayer here?
My lord, pray that the inquiry may be conducted within the supervision of my lord.
Inquiry should be conducted by High Court judge.
For what?
My lord, this is a case relating to flying of commercial vehicles, gold load vehicles through a village road, 30 kilometer of village road.
Where will High Court conduct an inquiry, please?
My lord, I'm not talking about inquiry, my lord. Inquiry, my lord, have already directed the inquiry to be conducted by the collector. I pray that the inquiry may be, my lord, my prayer is.
There is already an order of this honorable court.
My lord, the inquiry may be
that the inquiry should be
supervision of my lord.
High Court judge instead. What is
He
wrong?
wants that should be.
Then what is the wrong in by conducting the inquiry by the collector?
My lord had directed two things in the inquiry. One, the inquiry should be conducted within the affected areas, among the villages, and whenever the inquiry is conducted, it should be prior notice and information should be given.
So whenever the report comes, you can assign the report. Why should we entertain another repetition like this?
My lord, the inquiry is being conducted as per the letter of the collector. Now the inquiry is being initiated. It is being conducted in Sundargarh, in the district headquarters. These villages are 60 kilometers away from there. Tribal villagers cannot move there to 60 kilometers.
No. Now there is all of you people are there. You assist them.
Go to the spot.
Yes. And the collector will also go to the spot. That's what we have said.
Officers,
but no information regarding the meeting has been conducted till date.
Where you have said
only a letter has been issued.
Or you have a representation, right?
My lord.
You say the petitioner's representation dated 8 June 2021 and
23rd April 2021. Annexure 5.
No, that's 8 June 2021 be taken into account by the collector Sundargarh, who is conducting the inquiry. And if necessary, visit the villages where the petitioners reside as part of the inquiry. No further directions are called for in the present petition. It's disposed of.
Item 34. My lord, in this item, my lord, we are applying the above OP number 1, Union of India, my lord.
Take your appearance. OP number 1 is in item 33.
Yes, my lord.
All right.
Let him have extra copy we short.
We have disposed of the petition, sir.
Yes, my lord. Item, not short the copy. Item 34.
Yes.
May it please, your lords. Malas, I have been told, Malas, there's a defect, Malas, a small defect. Malas, the name and the mobile number, Malas, of the filing council has not been stamped on the first and last page, Malas. That's the defect, Malas. We'll do it right away, Malas.
All right.
Malas, the issue, Malas, involved.
The petitioner undertakes that defect 14(4) will be removed today itself. Yes.
Your lordships, now, Malas, the challenge, Malas, in this petition, Malas, this is again, Malas, the second round of litigation, Malas. The challenge, Malas, is on the assumption of the jurisdiction by the commissioner, Malas, to revise my order under 79 and 119.
There's no tribunal.
There's no tribunal, Malas. This is an order, Malas, which was passed by an officer delegated by the commissioner. And against this...
He's the additional commissioner of sales tax appeal, correct?
Correct, Malas.
So against this, you can't go to the sales tax tribunal?
No, Malas, because this is a revisionary jurisdiction. I have already...
Appeal lies to the commissioner under section 79(7), my lord.
But let me explain that, Malas. In fact, the entire order and the action has been done at the behest of the commissioner. And Malas, I'll point out, Malas, how this has emanated, Malas. If your lordship gives me a minute, Malas. Malas, what had happened was, Malas, that in the earlier round, Malas, I had been, Malas, earlier subject to an audit assessment where all my issues were examined. Thereafter, Malas, there was a regular assessment. After the regular assessment, there was a rectification. After the rectification, there was an appeal. And then, Malas, after the appeal, there was again a commissioner order saying that I should not be granted a refund. All of that was in my favor. Thereafter, Malas, the department decided that against this order and a statutory appeal to the tribunal should be preferred. That was preferred by the department, Malas. While that appeal was preferred, Malas, the commissioner directed the department to withdraw the appeal. And now the commissioner wanted to suo motu, Malas, exercise jurisdiction under section 79, Malas. This section, Malas, is akin to section 263 of the Income Tax Act. So, my lords, when that appeal was, my lords, withdrawn, a show cause notice was issued to me, my lords. I impugned the show cause notice before the first round, my lords. Your lordships considered that rate, my lords, and lordships may kindly have, my lords, the order, my lords, that has been passed by your lordships, my lords, in that rate, my lords, kindly have page 101 for a moment.
Yes.
102, my lords, kindly have para 5, my lords, serial number 5. Your lordships, my lords, your lordship mentioned that because this is a show cause, please go back and raise all grounds, including the questioning of the very invocation of 79.1. That's in 5.1. And in 5.2, your lordships directed, my lords, that this, my lords, will be considered uninfluenced by the stand taken by the commissioner.
Right.
And now, my lords, pursuant thereto, my lords, I was called, my lords, the original show cause notice, my lords, which was the subject matter of challenge before my lords, my lords, that was given up. There were no issues taken up. There was a fresh notice issued. I, my lords, replied to that fresh notice, and I said that whatever has been mentioned in this notice, firstly, were considered at 5 stages earlier, and secondly, it is not prejudicial. Now, my lords, on that basis, my lords, the impugned order has been passed, and kindly see the findings, my lords. Now, the original issues have been given up, 3 more issues have been taken, and my lords, that original order, my lords, is at page 69, and kindly have straight away the findings at page 84. These are the only 3 issues now which have been taken. 84 para 5.1, if your lordship has.
No, but you have not answered the question of maintainability.
My lords, on maintainability, my lords, kindly see, my lords. My lords, this, my lords, against the revision, my lords, if the revision is passed by the commissioner, I can file a statutory appeal before this honorable court. That is provided under section 79, my lords, which I have annexed, my lords. Kindly have section 79, which is at page 172. 172, I have section 79. Now, my lords, in this case, what had happened was that this revision had to be done by the commissioner, but there was a notification issue. And that
79.7 is what he referred to, correct?
My lords, 172 is what I'm referring to, section 79.
That's right. Subsection 7 is what Mr. Padi.
Correct, my lords. Now, my lords, kindly have 79.7. Now, my lords, the difficulty in 79.7 is, my lords, if I am under 79.7A, my statutory appeal is before your lords. Now, if I am under 79.7B, my statutory appeal is before the commission.
Correct.
Now, my lords, what had happened in the first round was, my lords, that the revision had to be done by the commissioner. The commissioner had issued a notification and said that this revision has to be now carried out by a officer which is, my lords, ranked with the commissioner. That's the additional commissioner. Now, my lords, when that order was passed, there was a counter affidavit filed by the commissioner before this honorable court saying that all of this has been carried out on my case. Therefore, my lords, I showed that para where your lordship said that everything has to be passed uninfluenced by the commissioner. Today, my lords, the jurisdiction itself has been clutched at. Because, my lords, all this order says is that these issues have not been examined. I show that one line. And, my lords, I show, my lords, all these issues were examined, my lords, 6 times earlier. So, therefore, my lords, there is nothing erroneous, there is nothing prejudicial. There is a refund which was granted to me 6 years back. They said, yes, this refund is agreeable. I'll give you this refund, but don't take it in this year, take it in the next year. So, my lords, both on erroneous and, my lords, prejudicial, the jurisdictional objections have not been granted. So, therefore, my lords, I am on a jurisdictional ground. Secondly, my lords, this is something which is on behest of the commissioner. Therefore, there is no alternate remedy. That's my submission on maintainability, my lords. And that I'll show, my lords, because it's a pure, neat question of law, undisputed facts, my lords, per se.
Yes, Mr. Padi.
The friend is referring to the counter that has been filed in the earlier writ application by the commissioner before this honorable court. This honorable court, while disposing of, said that uninfluenced by that counter affidavit, this honorable court, the decision will be taken. Now, there is a circular that if the appeal order has been passed by the joint commissioner, then the suo motu revision can be taken up by the additional commissioner. And if the first appeal order is heard by an additional commissioner, then commissioner himself will take up the suo motu revision. Now, in the present case, appeal has been heard by a joint commissioner. So, my lord, going by that circular, the suo motu revision has been done by the additional commissioner, my lord. So, as on date, the commissioner has not taken any decision in this matter, my lord. Only a counter affidavit has been filed.
No, he says this very initiation of the proceedings is at the behest of the commissioner. That's what his point is. Then he says it will be pointless to go before the commissioner in an appeal.
That is not, that doesn't burn out from the record, my lord. Because the commissioner has this power of suo motu revision and all has been delegated, and the lower authorities have exercised power. So Commissioner, except filing a counter affidavit before this honorable court, is not taken any decision, my lord, in this matter.
That was, my lords, with respect, my lords, that was not the point, my lords. What had happened, my lords, in the earlier, the department preferred a statutory appeal against the first appellate order before the tribunal. It was the commissioner, my lord, who wrote to the department saying that the has to be withdrawn and let me assume a super jurisdiction. Now, my lords, when that happened and I was before this honorable court, your lordships, my lords, granted me a stay and the matter was under consideration. Last time, my lords, when the matter came, your lordships were of the view, because we are at a show cause notice stage, your lordship must have a benefit of the order, and then if I'm aggrieved, I should come here. Today, my lords, what has happened is there is a 53 crore demand, my lords, which is on me. And secondly, my lords, on jurisdiction itself, my lords, this officer, my lords, has clutched at jurisdiction. My lords, these are fine, my lords. Whether the order is erroneous, your lordship have held. If it has, there is an application of wine and one plausible view has been taken, my lords, as per the Supreme Court in Malabar, etc., then, my lords, that is a case of a change in opinion. I can show, my lords, on all these three issues, my lords, one possible view was taken. And I showed it, my lords, and the finding is that no view is taken. And I can show that, my lords, it is a pure need question, my lords. I can show it in 2 minutes before your lords. And, my lords, now there is a demand, my lords, of 60 crores. I am required to pay it by the 1st of November, my lords. Therefore, my lords, my remedy, my lords, is completely not effective.
This is the second round of litigation by the present petitioner. Earlier, this court disposed of the petitioner's petition civil 8903 of 2018 by the order dated 25th March 2021, relegating the petitioner to the adjudicating authority who had issued a show cause notice dated 1st May 2018, namely the Additional Commissioner Sales Tax, Bhubaneswar. Paragraph.
That was the revisional authority. May I just?
Sorry?
That was the revisional authority, not my lord, adjudicating authority. The revisional authority.
Revisional authority. All right. Now, a revisional order has been passed by the Additional Commissioner of Sales Tax (bracket ACST) on 4th October 2021, and assailing that order, the present petition has been filed. Paragraph. Mr. Padi, learned Additional Standing Counsel for the Department, raises a preliminary objection as to maintainability on the ground that an appeal lies against the impugned order under section 79 bracket 7 of the Orissa Value Added Tax Act 2004 bracket OVAT Act. Paragraph. However, Mr. Jarwal, learned counsel appearing for the petitioner, contests the above objection by pointing out that earlier an appeal was sought to be filed by the commissioner against the
order of the first appellate authority, Manoj.
Against the order of the first appellate authority, which was then withdrawn by the commissioner, stating that a revision would be entertained suo motu. He accordingly submits that in the peculiar fact of the present case, the petitioner cannot be relegated to the remedy of an appeal before the commissioner. Paragraph. We say notice, Mr. Padi accepts notice, it will be open to the department in its reply to the petition to again raise the issue of maintainability, and be decided by the court while taking up the petition for hearing. Paragraph. Till the next date of hearing, no coercive steps be taken against the petitioner. The reply be filed within 8 weeks, rejoined up for the next date. List for hearing on 18 January.
Obliged.
35.
Malords, on behalf of Mr. Siddharth Das, even though our name appears, the consent has been given and we are no more appearing in this case, Malords.
All right.
Consent has already been given.
It is stated that papers have been withdrawn from Mr. Siddharth Das. They are no longer appearing. No alternative arrangements have been made. The petition is according to dismissal non-prosecution.
Obliged, Malords.
Item 36.
36, may I please? 36, my lord.
Yes.
My lord, it is a land acquisition matter, my lord.
Yes.
So I have already filed a dead chart, my lord. Lordship got it, my lord. The list of dead chart and events I have last time I filed in this case, my lord. It is in file, my lord, record. List of
Yes,
dates
yes.
and events,
Yes.
my lord. The case is like this, my lord. There are 4 petitioners. They have purchased the schedule of land in the year 2099 and also 2000. After purchasing, they have muted their land in their favor in the 2000 also. That are given a date, my lord, the dates, the purchase of the RSD and then the mutation. And the mutation RORs have been filed and under Annex 11 in my rejoinder affidavit in the name of the petition. Mutation ROR that has been published in 15/1/2003. The ROR has been separate. ROR has been named in the petition. Then, my lord, 1/9/2008, that was a land acquisition proceeding was started under the old act, that is Land Acquisition Act 1894, and accordingly, my lord, as per the section 17, the urgency due to urgency, the structure and of the petitioners were demolished and they were taken the possession. And in the 4-1 notice, the plot number of the petitioners not notified. It is admitted fact. They have not notified the plot numbers of the petitioners. And what happened? So that's why the petitioners applied under RTI Act to know the fact of their land. Lordship, kindly see my rejoinder affidavit, Annex 12. Rejoinder affidavit. I have filed. Only rejoinder affidavit.
No. Were you part of the earlier order dated 25th September 2012?
26?
You said there is a common judgment of the High Court on 25th September 2012.
Hello.
Just come to para 6.
My writ application, my lord.
Your writ petition, para 6.
My lord. That is, my lord, that the acquisition will be made because there are some persons who are public who are protesting that they will not give their land to acquisition. Man.
Kindly read para 6, please.
Para 6. That it is humbly submitted that being politically motivated, the authority changed the blueprint master plan of proposed road and new plan was prepared to take the road on the land of the petitioners by demolishing their house. When the demolition and eviction process was going on, the petitioners approached this honorable court via WPC number 3131 and 2011 and got on status court. However, in the meantime, other cases also filed by other inhabitants challenging the said construction of road. However, this honorable court had the matter combinedly and filed a judgment at 25/9/2011 at 12 gave a common judgment and directed that on acquisition of the property, the petitioners would be entitled for compensation on the basis of market rate prevailing on the locality, including solatium and interest. On the above reason, the writ petition were dismissed. So my respectful submission, till date, they have not notified my land under the acquisition. I was protesting not to give my land, not to demolish my structure. I lost. But this honorable court said that I will get the compensation according to prevailing market rate. So that's why my limited grievance is now. What happened?
No, why are you going on filing? My question to you is, you're going on filing fresh petitions. When no competition was filed, you should have filed a contempt petition. When you did not get competition, you should have filed a contempt petition.
Your Lordship, the entire competition has been deposited before the civil judge, Your Lordships. Your Lordships. Because there was some apportionment issue, Your Lordship, as to the owner of different plots of the land. They have deposited under Section 30 before the civil judge quota, Your Lordship.
All right.
My limited grievance is that. So my limited grievance is, Lordship, that the land they have now taken a plea that we have deposited the money in the name of the Sabak owners, the vendors of our vendors. That is admitted. And they have deposited money by calculating, apportioning in the court. Just that amount. Because what happened? They sold the property. They, without taking my land.
They had made Section 30 deposit they had made under Section 30.
That means it is open to you to raise your claim.
Yeah. No, my lord. That's true, my lord. But first of all, section 30 is concerned. What happened? They have deposited money in the name of the vendors.
Whatever your claim would be before the civil court, you show the sale deed, prove your title, get the money.
No, my lord, what happened, my lord? My lord, may I
His
please?
name has also been forwarded by the land acquisition officer to the civil court, your lordship, by letter dated 2014, your lordship. Since
I am not
2014, he
That's
has
why,
been
my lord,
civil judge. He is not approaching there.
My
The
first
filing
grievance is, my
continues
lord.
with petitions, your lordship.
Okay. My
This is
first
the
grievance
third
is, my
round
lord.
of litigation, your lordship. Third round.
My complete, my lordship is complete. My sole grievance is, my lord, the calculation which will be made because they will be according to the new act of 2013.
No, all that
because
you
they
can
have
challenge.
stated,
There will be an order passed under section 30, you challenge it.
then they have not deposited. Till yet they have not. My lord, my respectful submission.
Deposited in the civil court.
The civil court, my lord, I am not disputing. I will go to civil court. My limited
please go.
They cannot they have not deposited the money in my name. And they have deposited.
They will have to just deposit the amount. To whom how much should be paid will be decided by the civil court. That's the whole purpose of section 30.
Then that's why, my lord, section 30 would not be applicable because the section 30 of the Land Acquisition Act is said if there is a co-sharer, then there will be apportionment. Here is no co-sharer because who have sold the land, they have deposited money there with them.
Even if for Mr. Mahanti, for all sorts of apportionment, the section 30 will be applicable. It is not that limited to co-sharers only. It can also be apportioned among the several purchasers.
That's it, my lord. They are not the co-sharers. Because the question is, my lord, they are not the co-sharers. They are the
it is not limited to co-sharers, please. Section 30 is not limited to co-sharers.
Section 30, my lord, I'm just referring section 30 of the Land Act. After 30, my lord, of the Land Act. Dispute as to apportionment, my lord. May I please, my lord?
Yes, please.
My lord. When the amount of compensation has been settled under section 11, if any dispute arises as to the apportionment of the same or any part thereof, or as to the persons to whom the same or any part thereof is payable, the collector may refer such dispute to the decision of the court. Here, what happened, my lord?
So 1 minute, please. So your full point about only co-sharers, section 30 will apply is not correct.
No, because that's true, my lord. Because there is no question of apportionment. Because they have already sold their land. They are not entitled to any compensation.
You have to demonstrate that in the civil court. They will pass appropriate orders.
My lord, may
this is the third round of litigation concerning the petitioner's.
My lord, may one thing I will say, my lord, one thing, my lord. I will ready to take back my compensation. Only my limited grievance. The compensation will be calculated as per the new act because till yet they have not notified my land.
Of the
so that's why as per new act I with the calculation. My limited grievance that if I will get the money from the old act and I will not be able to purchase the land in market value.
First, the petitioner had filed along with certain others. Writ petition civil. No, first the petitioner had filed Writ petition civil 31319 of 2011, which was heard along with a batch of similar petitions, and a judgment was passed with this court on September 2012 that on acquisition of the properties, the petitioners would be paid compensation on the basis of the market value prevailing in the locality, including solatium and interest. Paragraph. When no compensation was paid, the petitioners filed a second writ petition being petition civil 1423 of 2013. This was disposed of with this court on 8 January 2014 with the direction to the opposite parties to furnish a copy of the land acquisition award to the petitioners within 1 month from the date of receipt of their application. Paragraph. For a third time, the present petition has been filed complaining that despite the application having been made on 27 January 2014 to the authorities, no compensation has yet been paid. Paragraph. In reply to the present petition, it is pointed out by the opposite parties that
the amount constituting the compensation for the acquisition of the property in question has been deposited in the Court of the Learned Civil Judge Senior Division Bhubaneswar under Section 30 of the Land Acquisition Act 1894, back the LA Act, on 26 November 2011. This is including the structure value, solatium, and interest calculated against the above land by the then Land Acquisition Officer, Khurda. Paragraph. It is submitted that despite the petitioners being aware of the above deposit of money in the court of the Civil Judge Senior Division, the present petitioners have neither submitted the required papers nor have cooperated with the LA staff during the inquiry for inclusion of names in the award. Full stop. Paragraph. It is further pointed out that on 12th March 2014, the LAO Khurda has written to the Civil Judge Senior Division submitting a Form 19 pertaining to the Khata number 183 of village Jagmara with the required papers. Full stop. Paragraph. The names of the petitioners are mentioned, right?
No, my lord, then 17. In the year 17, they have stated they are adding their petitioner's name. They have filed the annexed 10. That's why my grievance, my lord. He let no accusation against the petitioner.
No, your names figure or don't figure?
Even petition number 3 number is also not there. Page 10 of page 10, they have what happened there. In the pending application, they are filing a miscase in the 2014 saying that you include the names of the petitioner. That's why, my lord, whole problem. How they have they will include. And under Annex 12, in 13, they have stated that in our RTI that your land has been acquired. But my plot number is not there, nothing. When I filed the case, they have now in the 2014, they have filed a miscase to include the name of the petitioners. So that's the whole problem.
It is stated that a miscase been filed by the...
And miscase have been filed after the new act.
All right. For inclusion of the name of the petitioners. Full stop. Paragraph. In that view, the matter will be open to the petitioners now to pursue the matter in the Court of the Learned Civil Judge Junior Division for obtaining compensation in accordance with law. Paragraph. Counsel of the petitioner then prayed that a direction should be issued that the compensation should now be paid under the 2013 Act. Full stop. This prayer cannot be acceded to. Full stop. The acquisition took place and was completed under the LA Act 1894, and therefore compensation in terms of that act has to be paid. Paragraphs. The petition is disposed of in the above terms.
My lord, in this regard, I can say, my lord, the new act which is applicable to me, the old act will not be applicable as per the section of the new act, section 24. So that's why I have not.
We are rejecting that prayer, please. We are rejecting that plea. Yes.
Item 37.
My lord, may I give the time because it's an old case. The direction may be good to civil judge to dispose of.
We have not even gone there. Why should we give the direction? You go there first.
Item 37 may I pray on behalf of Mr. Harichandan. He is out of station as his cousin has been died.
Which
let it come next week.
The request of
interim order.
No, where is he? Mr. Harichandan is in some personal difficulty.
Yes, ma'am.
All right. They said that Mr. Harichandan is in personal difficulty today. Let's stop to 10 weeks. Interim order to continue.
38.
Well, it is a matter that the petitioner is continuing under suspension since 2018, my lord. And he is a chief financial officer working at the capacity of chief financial officer in the, my lord, corporation, that Orissa Small Industries Corporation. My
who is appearing for the other side?
My lord.
Yes, my lord. I am appearing for the other side.
All right.
My lord, in this case, I am challenging the.
Yes, please.
Yes, my lord. In this case, I am challenging this memorandum charges. We think it is a lack of jurisdiction by the MD. That is the sole challenge, my lord.
No, but why did you wait for the final order and challenge everything at that stage?
Because, my lord, I am saying why. Why I have challenged this. My lord, kindly see page 15. Now it is not there. My lord, page 15 of the writ application. My lord, kindly see. The board, after discussion, my lord, second para I am reading. Sri U. Misra, Joint Manager Finance Audit, as the Chief Financial Officer of the corporation in terms of Section 251, read with Section 23 of the Companies Act of 2013 for a period of 5 years by passing the following resolution. Resolved that pursuant to Section 23 of Companies Act 2013, Sri U. Misra, Joint Manager, be and is hereby appointed as Chief Financial Officer of Corporation for a period of 5 years, effective from 12/3/2015, who will be key managerial personnel. My submission before your lordship, this board of director has the power to suspend me and to give a memorandum charges. But MD suspended me because I have objected to some foreign visits of MD and all other problems, my lord. Being a chief financial officer, I have acted, and that is the cause of action, and I have avoided that. But that is no rebuttal on that point, my lord. That my prayer before your lordship, because I have been objected to some misdeeds of the MD, he suspended me and issued this memorandum charges. And on and from that date, my lord, from 2018, I have challenged that case, my lord. That is also tagged up with this case.
No. So the point really is, let the inquiry be concluded.
Yes, my lord. That's I'm not saying, because he must have the power, authority to do so. Now this 5 years has already been completed. This 5 years of that I am a key managerial personnel. That 5 years period where board of directors has the power, the MD has no power. That's why I have alleged also nullified, because there is some financial irregularity and that is been surfaced. That's why he just wants to sent me out from the Cuttack, and that's why he suspended and my place of headquarters placed.
No. Who's your inquiry officer?
My lord?
Who's the inquiry officer?
My lord, they have appointed one inquiry officer. That is my joint director level, my lord. And this was when. That's why, my lord, I have approached your lordship, my lord. Kindly see, my lord, Annex 6, that is the memorandum. What is the allegation against me, prima facie, my lord? That allegation is I am talking to somebody that and giving the information, like the Tally software.
I'm just asking you a simple question. Who's the inquiry officer?
Inquiry officer, my lord, appointed. Inquiry officer, my lord. They have appointed inquiry officer in the meantime or not?
My lord, Engineer Ranjan Kumar Kara, my lord, GM operation.
All right. So he's a superior officer to the.
Yes, my lord. Yes.
You are a joint manager. He's a general manager. So you take this plea that there's no jurisdiction to issue.
No, my lord, after 2020, the MD has the jurisdiction because that period is over. So they can issue a fresh charge sheet and they can inquire.
That's only a ritual then.
My lord, that's why, my lord, but I am continuing under suspension. And for last long suspension, prolonged suspension is bad in law, my lord, that I am referring to Ajay Chaudhary case. From 2018, I am under suspension. Your lordship may say that if there is, they want so serious about the charges, they can give a fresh charge sheet and they can continue.
No, so you have challenged the 26 July 2021 order here.
My lord?
Yes, my lord.
That itself is an interlocutory order.
Yes, my lord. That order, which order, my lord?
The writ appeal has been filed against an interlocutory order.
No, my lord. 4/1/2019 order. Page 40. To my writ appeal, my lord. That is the order, my lord, that the disciplinary authority who initiates everything.
No,
that
the writ appeal is filed against which order, please?
My lord, yes, page 40, my lord.
The writ petition has been disposed of. Which is this other writ petition, 21129? 1636. Something wrong in that typing. The prayer clause, I think we got a extra number.
My lord, 16238.
What you typed is 162367. Look at the prayer clause.
It's wrong. It's a typing mistake.
This is a perfectly valid order. After which you've again filed another writ petition, is it?
Well, that is under for release of suspension, because I have challenged that suspension order first, and this honorable court, without going into the merit, and said the last place of posting should be Cuttack or Bhubaneswar, should have sent me to the Koraput, Jaipur. Then MD did it as Anugur, and to release they didn't release my substance allowance for substance allowance. Then, my lord, this the suspension order I have challenged because of this.
No, Miss Mahapatra, you see in the first title, you have said assailing the order dated 4/1/2019.
My lord, that is.
But in the prayer portion, you have said something else.
7
May I submit, my lord? My lord, in the writ application 16238 of 2018, out of which the writ appeal arises, in that writ application, they have challenged the order of a memorandum charges dated 24/7/2018.
No, Mr. Mahapatra, that's a typographical mistake. You see the page number 1. So that may be due to copy paste of the told. In the page number 1, he has said that he challenging 4/1/2019 order. Yeah.
My lord, my respectful submission, 4/1/2019 order has been challenged, but correct. That order has been passed in the writ application number 16238 of 2018. Correct. Wherein in the writ application, they have challenged the memorandum charges dated 24/7/2018.
Correct.
My lord, your lordships have looked to Annexure 6, the page 40 of the writ appeal. The order has been filed, my lord.
Yes.
That is the impugned order. In that, the honorable single judge has directed, my lord, I am reading this order, my lord. The aforesaid, my lord, the petitioner has filed this application seeking to quash the charge sheet dated 24/7/2018 in Annexure 4. That was in Annexure 4 in the writ application.
Yes.
On the ground that the authority who passed the order has lacked jurisdiction. The aforesaid question can also be considered at the time of adjudication of the case before the said authority. Therefore, the court is not inclined to entertain.
No, that we are agreeing with. So there's no difficulty on that.
My lord, my respectful submission, prior to this, my lord, this petition has challenged subsequent by filing subsequent applications. Initially, challenging the order of suspension has filed a writ application 9939 of 2018, challenging the order of suspension.
No. Whether he has challenged the charge sheet. Yeah. Charge sheet was challenged in this 1623.
Yes, charge sheet was challenged in 16238.
Correct. Yes, my lord.
Not prior to that. Suspension is on a different aspect.
My lord, that was challenged in 16238.
Right. Yes. Anyway, so why is that?
My lord, in the memorandum charge sheet,
you have not still paid subsistence allowance.
My lord,
you have not paid the subsistence allowance.
Yes, my lord, I am paying the subsistence allowance. I am paying.
So this 21129 is for what purpose then?
My lord, that is a single bench matter, my lord. And because of this pendency of this writ appeal, the honorable single bench stated that this may be moved before the division bench, my lord. And in that, my lord, I am challenging that no, they have not paid. Every time I have to come before this honorable court and get a suspension allowance. That in that case, my lord, I have challenging the suspension order because, my lord, that suspension order to 2018, as I am challenging that on the ground of that this is also lack of jurisdiction, and my lord, that is not.
No, but till the inquiry is over, how can they remove?
No, your lordship, my lord, that if
you come here, you get a stay. Naturally, the suspension will continue.
My lord, with suspension memorandum charges has nothing to do because they have already given me. Giving me.
How can they allow you to resume work when
when the inquiry officer has been appointed, in view of the stay order passed in the writ appeal, the inquiry was stalled.
Correct.
Because yes, my lord, because I have alleged malafide, but now authority has been changed.
So we're going in circles. So once we agree with the learned single judge,
We'll record, you have filed a reply.
Yes.
So what stage it is? Only examining witnesses.
My lord, that is the inquiry officer appointed, my lord. That is the.
No. So inquiry will give a time-bound direction to complete the inquiry. You cooperate. You don't take adjournment. How many witnesses are you citing?
That stage, my lord, but I have not given my reply, but I will cooperate, my lord, to complete.
So
that
we complete it in 6
but-
months, the inquiry.
But my lord.
They will also be relieved to have it completed early. All your pleas you reserve. If the inquiry goes against you, you reserve it at that stage.
They have not taken any step to list it before your lordship. Only after the single bench order, my lord, I myself mentioned it and your lordship granted, listed it to
All right.
your lordship.
Even that second one, you can dispose of the writ petition also.
Yes, my lord. Your lordship may dispose of all.
All right. You say the present writ appeal challenges an order dated 4th January 2019, passed by the learned single judge, dismissing the appellant's writ petition civil 16238 of 2018, in which the appellant had challenged a charge sheet dated 24 July 2018, issued by the Orissa Small Industries Corporation Limited, OSIC, through its managing director. Stop. The learned single judge was of the view that all the pleas raised by the appellant questioning the jurisdiction of the authority who issued the charge sheet can be considered at the time of adjudication of the case, and therefore the writ petition was not being entertained at this stage. Paragraph. In the present writ appeal, while issuing notice on 6th February 2019, this court had stayed further proceedings pursuant to the aforementioned charge sheet dated 24 July 2018. Paragraph. Today, having heard learned counsel for the parties, the court is of the view that the impugned order of the single judge does not call for interference. It is reiterated that all the pleas of the petitioner questioning the jurisdiction of the managing director of OSIC to issue the charge sheet can be raised by the petitioner in the defense in the inquiry, and can be raised if the outcome of the inquiry is adverse to the petitioner at the appropriate stage in the appropriate forum. Paragraph. Meanwhile, the petitioner has also filed writ petition civil 21129 of 2018 before the learned single judge on the ground that the suspension allowance was not being released from June 2018 onwards. Paragraph. Mr. Jatindra Kumar J.K. Mahapatra, learned counsel for the OSIC, maintains that suspension allowance was in fact being paid to the appellant public petitioner regularly. Full stop. Since when was the last time you paid suspension allowance?
My lord.
When was the last time you paid suspension allowance?
My lord.
It is reiterated that if not already paid, the suspension allowance should be promptly paid to the petitioner by his OSIC before the 10th of every month.
Well, that has been regularly paid, my lord.
All right. Paragraph. It is further directed that the inquiry itself now be completed within a period of 6 months from today, and in any event on or before 1st April 2022. This will, of course, it's further directed that the appellant will fully cooperate in the inquiry and not seek any unnecessary adjournments. Full stop. It is, of course, open to the OSIC to conclude the inquiry earlier as well, in accordance with law, if it is able to do so. Paragraph. With the above directions, the writ petition civil 21129 of 2018 is disposed of,
writ appeal number 33 of 2019 is dismissed. In the above terms, the interim order passed with this court stands vacated.
Regarding release of suspension, Lordship may say that authority will consider it regarding release of suspension. For last 5 years, I am under suspension.
That we have said. No, allowance. She wants to release a suspension itself. Revocation of suspension. Revocation. You say it will be open to the petitioner after a period of. No, in the event that the above time-bound direction is not complied with and the inquiry does not conclude on or before 1st April 2022, it will be open to the petitioner to apply to the OSIC for revocation of suspension. All right.
Item 39.
Graduate. Urgent copy, my lord.
All right.
Even counter, my lord. 39, my lords. May I also pray, my lords, that I have also, my lords, at previous occasion had directed opposition party number 1, the state government, to file the counter, my lords. That is ready, my lords. I'll file it in course of the day. And one more thing I'd like to bring to my lordship notice. In the counter, I also mentioned in the previous counter by opposition number 7, that is the district education officer DO. My lords are directed to, since it is a policy decision and the virus has been challenged. So my lords are directed to that the state government should file, and we have already made it ready. We'll be filing in course of day. And there, my lords, I'd like to bring to my lordship notice that the same this has been challenged. Virus is in the Orissa Administrative Tribunal, and that has been transferred to this honorable court and renumbered as OAC number 471 2017, my lords.
My lords, I can, my lord.
That, my lords, that has not brought the lordship's notice, my lords. That I've got in my counter also. That is already there in OAC number 471 of 2017. In the previous counter also, that I've mentioned. And that I've annexed in this counter also. Anyway, I will be filing the counter in course of day, my lords.
My lord, brother is filing counter, it's all right. But where you are challenging the virus of the provision, whether different having teachers having different qualification can be posted in one cadre. That is what is under challenge. That original application can be gone into in single bench, because it is a single bench matter. There the allegation is that we are trained graduate teachers, we are given the responsibility of primary teachers, and we are not given the responsibility as per the law laid down by
Anyway, he is not asking for linking that petition.
No, it is independent, and that is independent. This will be dealt with separately.
Mr. Parida states that the SNME department is filing its counter affidavit during the course of the day. Rejoined to be filed for the next date. List after 12 weeks. Right.
Obliged.
40.
40, my lord, on behalf of Miss Mahapadra, kindly.
I am here. Sorry. Lordship may kindly pardon me, madam.
Yes.
Lord, I am there. I am there for the petitioner.
My lords, in this matter, my lords, I have filed the application for intervention, my lords. I am appearing through VC, my lords.
Right.
I filed the application for intervention, which is at flag B, my lords.
Right.
Here in this case, my lords, in the auction of the SAT.
Let me argue your intervention will be considered. If my lord considers necessary, they will allow you to participate.
I'll just submit, my lords, with permission of my lord.
So you want to delay the whole process. I have let me argue on merits. I have entire pleadings are over in this matter. Petitioner is there. They have filed counter. I have filed rejoinder. And you have fought the litigation at your behest three times, and you have lost it. And your appeal is pending before the sub-collector. Now you are trying to intervene here in some other matter.
That is why, my lords, when my appeal is pending before the sub-collector, I have not been made a party in this writ application, my lords. I was the highest bidder, my lords.
Lord, it is arising out of the collector's order. Now, before the collector, you did not make application to intervene. Now, when the matter is ready for hearing,
I was not made a party.
But I pray your lordship, let him wait. Let the matter be argued before your lordship, Lord. If at all your lordship feels his presence is necessary, your lordship may allow it.
All right. We'll keep it at the end of the board, so it will take time.
Right, my lord. As your lordship please.
Right.
Item 41.
Item 41, my lord, is directed to file an affidavit that has been filed, my lord. It's on record. I'm for the CMC, my lord.
My lordship, I am for item 41. My lordship, it is regarding this matter is regarding the inaction of the opposite parties is not allotting the selected vending zone in front of the government press shop Khapuria and not working out the order that has been passed in WPC number 24162 of 2019 that is passed in 3/1/2020, my lord. My lord, we have received the counter yesterday only, and it will take some time to prepare the rejoinder, my lord.
All
So we
right.
would like to have 2 weeks of time, my lord.
All right. The CMC's affidavit is on record. Counsel, the petitioner seeks time to file a rejoinder. Seeks and is granted time to file rejoinder before the next date. List on 18 January.
Oblige, my lord.
Oblige, my lord.
Item 42.
Lord, item 42, before I take your lordship to the merits involved here, I have applied for amendment because there are certainly developments taken place during pendency of the petition. Even before that also, the license has been issued in favor of the successful person that is required to be challenged. So I have applied for amendment. I have also filed the consolidated copy to courts at the time. Lordship, allow my prayer for amendment and take up the matter.
All right, 14524 of 2021. This is an application seeking to amend.
Lordship, I am appearing for OP number 5. Time may be given for filing the counter.
Yes, you see.
Consolidated writ
For the
petition
reason
may be
stated
served.
therein.
Mr. Ratha may serve the consolidated writ petition.
Yeah.
I'll serve.
Inter alia challenges the license issued in favor of opposite party number 5. Without prejudice to the rights and conditions of the parties, the application is allowed. The consolidated writ petition is taken on record.
Right.
In the main writ petition, counsel appearing for opposite party number 5 seeks and is granted 4 weeks time to file reply rejoinder before the next date. List on 24th January 2020.
Right.
Item 40.
So we'll come back after lunch.
Supplementary list passed over matter, item number 40. Item 40.
In this case, my lord, I am appearing for opposite partner five, my lord.
Right. Let Mr. Rathore come.
My lord.
Am I audible to your lordship, my lord?
Yes, Mr. Rathore.
Right. Lord, here in this matter, I am challenging the order passed by the collector annexure 1. The impugned order starts from page 18.
Yes.
Lord, before I take your lordships to the merits involved here,
yes,
Lord, there may be a question against me that there's an alternate remedy available, appeal to the RDC.
Yes.
Section 46 is there.
Right.
The question of filing of an appeal may arise against me. So I must answer that before I take your lordship to the merits involved here.
Right.
Now, my lord, your lordship will see, look at section 51, because it says here the collector has passed an order to cancel my liege. I mean, collector has already cancelled. Collector has passed order, page 21, your lordship says, has cancelled the liege itself, page 21. Ordering
Yes.
portion, your lordship would kindly take the pen of looking at page 21 towards bottom.
Right.
Collector has passed order cancelling my liege.
Right.
And thereafter, directing to stop lifting of sand from the Saira and immediate effect and amount deposited by the petitioner in this regard to be forfeited.
Right.
So these are all penal orders passed by the collector. My humble submission before your lordship in this regard is that collector, being the controlling authority within the definition of the Minor Mineral Rules 2016, has no power to pass this order of cancellation of liege.
Right.
It is the competent authority only has power to cancel under the contingencies and mentioned in the rules itself, not the collector.
Right.
So in that view of the matter, willful comes into application, my lord, and I say that this impugned order is completely without jurisdiction and comes within one of those three principles mentioned therein, when it is completely without jurisdiction. And your lordship, now therefore I request your lordship to proceed, allow me to proceed on merits. If your lordship permits me, then I'll go on better.
No, what order could have been passed by the collector then? Once he found that the solvency certificate is not valid.
Right, my lord.
Then what order should we pass?
My lord, your lordship will see section 59, section 51, subsection 7 gives the way, my lord. In case of breach of any, this is the only power of cancellation of lease, my lord. There is no other power under the rules. In case of breach of any condition of the lease, lordship has got that rules well.
Yes.
Right. In case of breach of any condition of the lease deed, the competent authority may give notice of 60 days to the lessee to rectify the defect within the time specified. And if the lessee fails to rectify the defect within the time specified, competent authority may cancel the lease and or levy a penalty not exceeding rupees 50,000. This is the only.
So Schedule 4 gives us who the competent authorities are.
Right, my lord. Schedule 4 competent authority is the Tahsildar, my lord. Lordship may kindly see. Schedule 4, third column, minor minerals when occurring within the boundary of village, Tahsildar. Now, Schedule 3, one second. And Schedule 3 gives the provides the controlling authority.
So competent authority is only Schedule 4.
Competent authority is at Schedule 4 within the definition of Rule 2F, and Rule 2G defines controlling authority. Controlling authority is the collector.
No, but there was an earlier petition here. Correct?
So those things, my lord, if your lordship permits me, I'll take your lordship to those fact of the case. Now, my lord, what happens here?
I think it went to the collector because of our order.
Right, my lord, your lordship relegated the matter back to the collector at the behest of the OP number 5, who challenged my solvency on the ground that my solvency is a fake solvency. That's the ground on which they challenged my solvency. Now I'll take your lordship to the background, little background of the case, my lord. Right. It's necessary to be brought to your lordship's notice. Now, during 2018, on 8th of January 2018, the auction notice was published.
Yes.
I have annexed the auction notice, my lord, that is at page 23.
Yes.
Now, in this auction notice, this is of course in vernacular. The translated copy has also been given. But then in auction notice, the present petitioner, OP number 5, and another Sukanti Lata Shahu, they participated in the auction.
Yes.
In that very auction, this petitioner was second highest bid. Sukanti Sahu was the highest bid.
Yes.
Now, Sukanti Sahu defaulted in making payment as required by Tahsil office, and there was an allegation that Sukanti Sahu had overlifted sand somewhere and she was a defaulter in those. They are not the facts here, but then Sukanti Sahu, since was a defaulter, was directed to deposit some demand. He did not deposit. That is how I was called upon to give my option as to whether I will be willing to take this source or not. But that letter, your lordship will find, that is also available on record, my lord. That is also there, my lord. Lord, I was called upon, page 45, my lord. I was called upon to execute, if at all I am willing to execute the lease deed and operate the source. Now I deposited about 97 lakhs. I gave my opinion. I gave my willingness to operate the source. Now, my lord, when I gave my consent, the highest bidder Sukanti Lata Sahu filed series of cases in this honorable court and got a stay order against me, as a result of which the lease deed was not executed in my favor. My lord, I contested those proceedings, which reached a quitus by your lordship's order. That order your lordship would kindly turn to have annexed that order when your lordships, in fact, that is at page 66, your lordship may kindly turn. Here your lordship will infer how the successful bidder and the present OP number 5 are conniving to see that I don't operate the source. Lordship will kindly see this below. Page 66, your lordship may kindly see.
Yes.
Annexure 18. By this order, in fact, the stay order which was obtained by the Sukanti Sahu was vacated, and subsequent thereto, at page 69, the matter was given a quitus by your lordship directing Sukanti Sahu to file an appeal. Now, 3 months thereafter, she has filed appeal. Milord, that's not the issue here. But then, meanwhile, Milord, like the lease deed was executed in my favor at page 53. Milord, on the basis of the lease deed, Milord, this environmental clearance and other statutory formalities were clarified, obtained, and I operated the source. Milord, this very private OP number 5 since 2018 was sitting at the bay, and she was never coming forward to court challenging in any manner. After the stay was vacated, lease deed was executed, the OP number 5 woke up from its slumber and she approached this honorable court challenging my solvency certificate, saying that the solvency is a fake solvency. Now the fake solvency issue, I will address to your lordship. Admitted fact remains that applying for solvency certificate, the property in the name of my family trust was given. The property in the name of my family trust, where I am also a trustee, was given along with the application. That is there, my lord. This is admitted fact. Now, sub-collector, competent authority, passed an order to issue solvency certificate in the name of the trust. That is correct, my lord. That fact also goes admitted. But that your lordship will find, that is at page 26, man. Page 26, sub-collector Atgad passed an order to issue solvency in the name of the trust. Now, solvency certificate was issued in my name. That is at page 27. Individual name, man. Now, this solvency certificate was used by me for this auction. Now, it cannot be said that is a fake certificate. If your lordship would kindly see one letter issued by Tahsildar at page 72. At page 77, my lord. I'll request your lordship to kindly turn to page 77 and just look at that. Page 77. Tahsildar Narsingpur, who is the authority competent, he has himself certified that the certificate is genuine. Kindly turn to page 77 and Annexure 22, my lord. Lordship is looking at that, my lord.
Yes.
Kindly see the last line. The said certificate issued by miscellaneous certificate case number 3 of 2017 is a genuine certificate. Genuine. So it cannot not the OP number 5 must understand that what is the difference between a certificate which is stated to be false and which is an incorrect certificate.
Yes.
But therefore, it can at best be said that a certificate issued in the name of Ranjan Kumar Patnaik, when the sub-collector passed orders to issue in the name of the trust, is an incorrect certificate. That can at best be said, my lord. But it's not a fake certificate. Now, my lord, what I am trying to tell your lordship is that this issue was raised by a person who was the third bidder. Now, your lordship might kindly see Rule 27, Sub-Rule 9, my lord. Wherefrom she derives a locus to raise this issue. Kindly see Rule 27, Sub-Rule 9. Lord, my humble contention is that this OP number 5, at no stretch of imagination, is a person aggrieved, nor has any locus to raise this issue. Kindly see, my lord, 27, Sub-Rule 9.
Yes, please.
Lord, in the event of default by the selected bidder, here the Sukanti has defaulted, the competent authority may issue intimation as specified in Sub-Rule 6 to the next highest bidder, who shall then be required to convey his acceptance and to make the security deposit calculated in the manner mentioned in Sub-Rule 7. 10. If the second highest bidder has quoted unusually low price in comparison to the highest bidder of the same source or other sources in the vicinity, the competent authority may bring it to the notice of the controlling authority, who after proper verification and with due justification may cancel the bid and direct for fresh auction. So what I am trying to derive from these two subsections, sub-rules are that, there is no role of a third bidder to come into and litigate for getting the source on the ground that I am the third highest bidder. The whole process is confined to the highest bidder and second highest bidder. If at all the second highest bidder fails in the process, the matter goes for a re-auction or a fresh auction. The third highest bidder has no play in the in between and is not at all cannot be said to be a person aggrieved to challenge the process or challenge my solvency certificate. Right. Now the question is, if your lordship would kindly see, just by Motibai Desai 76 Supreme Court, your lordship must have come across this judgment innumerable times, my lord. Just by Motibai Desai 76 Supreme Court, my lord.
Yes.
Lord, the word may be permitted to place it a small paragraph. Of course, the judgment was not.
All right.
The word person agreed do not really mean a person who is disappointed of a benefit which he might have received if some other had been made. A person agreed must be a man who has suffered a legal grievance, a man against whom decision has been pronounced, which has wrongfully deprived him of something, or wrongfully refused him something, or wrongfully affected his title to something. Therefore, in my humble opinion, the OP number 5 here is cannot be said to be a person aggrieved. Now, in my humble submission, the successful bidder who lost the litigation after 1 year, both this 5 and they have connived, and that they want to see that this person doesn't operate the source well. My client has deposited 97 lakhs, executed the lease deed up 94. I'm sorry, I stand corrected. It is 94 lakhs. Executed the lease deed. In the midst of operation, this OP number 5 comes into picture suddenly, and on the ground of this solvency certificate, he is trying to delay and stop the whole process. Now, the operation has been stopped by order of the collector. The lease has been cancelled, and I am in the midway now. Now, what I am trying to contend is, Rule 51 Sub-Rule 9 is the only provision where I should have been put forth with a notice of 60 days to remove that, to rectify the defect, if any. Such a notice has never been given by the collector to me. Before the collector, the issue was as to solvency certificate. Now the collector is directing cancellation of my lease, forfeiture of my entire amount, my lord, which was never the issue before the collector. So in any view, in keeping in view to all these circumstances, my lord, I'll request your lordship, the let Rule 51(7) be complied with.
Right. Yes. Mr. Monty, you want to go first? Yes, let Mr. Monty first address.
Right.
My lord.
So the competent authority.
Now, let me place the status of the parties. The petitioner is in fact the second highest bidder, and the intervener now Sukanti, he was the highest bidder, And the Devidatta Mahati, for whom Ms. Dipali Mahapatra senior advocate is appearing, he was the third bidder. Now, the collector was called upon to dispose of the representation of this opposite party number 5 by order of this court, wherein he has alleged that the certificate issued was a fake certificate. And the collector found that the certificate was in favor of a trust in which Ranjan Kumar Patnaik was a party. Trust is not the lessee. Lessee was Ranjan Kumar Patnaik in his individual capacity. So the collector found that the solvency certificate is fake one. And
not a fake. Not proper. See, the solvency certificate is a genuine one, but it is in the name of the trust.
Yes.
It's not a fake certificate.
And another thing is that certificate was subsequently cancelled because of this reason. That it is not in the name of Ranjan Kumar Patnaik. That is first part. So far as, and that is why the collector has held that this certificate cannot be the basis of awarding the work in favor of the petitioner. And if that is so, the consequential result is the lease has to be cancelled.
That's where the problem is, correct? So the schedule 4 gives the list of competent authorities. And for cancellation of the lease, it is Tahsildar.
No, my respectful submission is that controlling authority is the head of the state district, and he is the
no.
In the advertisement for the action, the stipulation is that the collector, the controlling authority, the collector, as well as the competent authority can cancel.
So that's contrary to the rules. So just see this.
So what I find from the impugned order that the collector has in the first part recorded a finding that this is a fake certificate and ought not to have been utilized by the petitioner.
It's not a fake. I don't think he says it's fake.
Collector has not said a fake certificate. Collector has not said like that.
It is a forced matter. And the consequential effect is since you have used this illegal certificate, therefore the lease is cancelled.
In the representation is alleged, but that's not the finding.
In the representation of the opposite party number 5, that is alleged that it is a fake certificate.
No, but what's the finding?
Finding.
Finding is at page 21.
That is at page 21, my lord.
Page 21. Page 21.
21, first paragraph towards end. But the Tahsildar Narsingpur has issued impugned solvency certificate in favor of Ranjan Kumar Patnaik against the schedule of land recorded in the name of trust. And trust is my family trust. I am also a trustee.
Maybe, but
I have given the trust deed also. I have also given the trust deed indicating my name.
So there is no finding it is fake or forged.
No, my lord.
There is no such finding.
No.
But the trust is not the lessee or not.
That may be different. See, we are now on fake or forged. That's on the merits. Now, first, let's go step by step.
Yes.
Assuming that he has produced a solvency certificate not in his own name but in the name of the trust.
Trust in which he is claiming to be a party of that trust.
He may be. I'm saying we assume at the highest that he could not have done that.
Yes.
The consequence of cancelling the lease, who can exercise that power is the question. His argument is under Rule 51(7), only the competent authority can exercise that power.
With 60 days notice.
And he may have replaced. See,
Yes.
if he had been told that trust's solvency certificate will not hold good for this, he may have replaced it. He may have got a solvency certificate in his own name. It's
I
only
have already done that. I have also already done that, page 80. I have already done that. Page 80.
If it is fake or forged, it's a different altogether, because forgery vitiates everything.
Yes, yes.
That is, as I find, there is no positive finding that it is a forge.
Yeah.
But this is in the name of the trust, not in the name of
Correct.
the
So he says, I have immediately replaced it. That's what he's just now saying. Anyway, under 51(7), if he had been given 60 days notice, he may have replaced it. It's like removing a defect. It's actually giving a chance to rectify the defect. This will only be a defect. Because once even the solvency certificate in name of the trust is attested to be genuine, there's a letter saying it is a genuine solvency certificate.
So far as trust is concerned, that is genuine. But
No. Even that certificate is genuine. That's what the Tahsildar has said. That certificate issued in the name of trust is genuine.
Trust is not the lessee or the applicant.
No. So I'm only saying it is neither a fake nor a forged certificate. If he had produced, even in the name of trust, if it is a fake certificate, he goes out.
Yes.
No question.
Yes. That is the grounds we have taken in our counter affidavit.
There's a huge difference between a fake certificate and a genuine certificate which is not in the name of the lessee.
Right.
Yes, let's hear the others now.
Yes.
Ms. Mahapatra. What is your locus standi? You will have to tell us.
No, my lord, from the beginning, your lordship will kindly see the tender paper. There is a condition to file solvency certificate.
No, your locus. First, your locus.
My locus is, my lord, in the threshold, the application of the petitioner is to be rejected. He is not a eligible tenderer. Therefore, I being the second tenderer, I have the locus standi.
No, you're the third. You're the third. Sukanti was the second.
No, Sukanti is the first.
No, but anyway.
Petitioner is the second. But the second bidder is ineligible and incompetent to be a second bidder because of the fact that he has submitted a solvency certificate not as per the norm of the tender paper, my lord. His application is to be rejected at the threshold.
Not really. Just come to 51(7) now.
Your lordship, thereafter, 51(7) I have seen, my lord. May I permitted to place the facts? Then your lordship will go to the law, my lord. My lord, your lordship will kindly see he has applied for a solvency certificate, giving the property of the trust. And your lordship will kindly see Annexure 3, where the sub-collector has said that the solvency certificate should be issued in favor of the trust.
Yes.
Page 26.
Correct.
But the Tahsildar, instead of issuing the solvency certificate in favor of the trust, have issued the certificate in favor of the petitioner. In spite of the direction of the superior authority, the Tahsildar has granted the solvency certificate in favor of the petitioner, and that solvency certificate was used in the tender, my lord.
That's why that may be a defect. That may be a defect.
My lord, if the tender paper enclosing the solvency certificate of the trust would be given, then my lord, his tender paper is to be rejected at this threshold.
No, where do you get the threshold part? Now come to 51.7.
Because your lordship will kindly say the tender condition.
No, correct. So there is a difference between, that's why 51.7 says if there is a defect, you have to give him a chance to cure the defect.
My lord, he could not have participated in the tender because he has not submitted the solvency certificate as required by in the tender paper.
No, but the facts. But if you go by your narration of facts,
my lord,
wrongly they accepted that solvency certificate and granted him the lease.
That is not wrong, my lord, because of the solvency certificate submitted individually in the name of the petitioner. That's why, my lord, the tender paper was accepted.
No, I don't think. I think something.
Yes, Annexure 4. Annexure 4 was issued in the name of the petitioner instead of the trust.
All right.
Instead of trust, my lord, it was issued individually in the name of the petitioner.
Okay.
That's why, my lord, his tender was accepted.
No, anyway.
Otherwise,
one minute. So let's go step by step.
My lord.
So this solvency certificate he enclosed with his bid, correct?
Yes.
And the bid was accepted.
Yes.
And a lease was executed.
Yes.
Now you have applied for cancellation of that lease. You have come with a petition. Your allegation was that this solvency certificate is a forged document. This was your allegation.
Yes.
Which is not true. You are yourself now saying that the application was made for a solvency certificate in the name of the trust, but it was issued in the petitioner's name, which it should not have. You're not saying it is a forged one, because this document, which is at page Annexure 4, is not a forged document.
Your lordship will kindly see, I have not stated that it is a forged document. I have stated in my representation that the solvency certificate submitted by the petitioner is not acceptable because of the fact that the solvency certificate should have been issued in Guru Krupa, that trust, my lord. Therefore, his lease be cancelled. My lord, the solvency certificate.
So you asked for cancellation of lease, correct?
Your lordship will kindly bear with me, my lord.
No, we are bearing with you. I'm just asking you for a fact. Your prayer in your petition was the lease should be cancelled, correct?
Your lordship will kindly. Because that, my lord. Annexure 3 was issued by the sub-collector to grant the certificate in favor of the trust, which the Tahsildar has granted individually in the name of the petitioner. And lease dues were executed, my lord. Your lordship will kindly see the appeal lies to the collector.
One minute, you are jumping. Madam, you are now jumping.
I am not jumping, my lord.
Yes. We are trying to understand from you that in your application or petition, you asked for cancellation of the lease, correct?
Yes.
What is the procedure for cancellation?
My lord, without seeing the statute, my lord, I will say that if any of the tender.
Why should you without seeing? Please see the rules. When we write a judgment, we have to see the rules and write the judgment. So you also receive the rules and tell us.
Yes, my lord. Yes, my lord. If there is any violation of the condition prescribed in the tender, then, my lord, the lease would be cancelled.
No. What is the procedure?
Procedure, my lord.
57.
40.
51.
51.7.
7. Subclause.
That 51.7, my lord, I have gone, my lord, 60 days notice. Your lordship is your lordship will kindly see section rule 46, my lord.
All right. What does 46 say?
That is appeal.
That's only procedure for filing appeal.
Any person agreed.
No, we are still in the earlier stage. We are now in the stage of you want the lease to be cancelled. We are only at that stage.
But in the tender notice, it is said that if any of the condition will not be fulfilled, then the tender will not be accepted.
True. So now, see, by a wrong premise, because instead of giving his own solvency certificate, he did give his own solvency certificate. That was not a correct solvency certificate because it should have been issued in the name of the trust. All right.
Yes.
So a lease has been executed in his favor. You have pointed out that they should not have accepted the solvency certificate.
Yes.
And therefore the lease should be cancelled.
Yes.
What is the procedure is the question. How will they go about cancelling?
Like, Melody, cancel on the ground that here, yes.
Whatever ground, let's say there are 10 grounds. Let there be 10 grounds for cancelling. What is the procedure?
Your Lordship will kindly, my Lord. Once the Tahsildar passed the order giving lease to the petitioner, my Lord.
No, procedure for cancellation.
Cancellation, my Lord. Against that, I have filed appeal under section 46.
No, that is it is not that.
Anyway, all right. Anything else, madam?
Your Lordship will kindly see, once the lease has been, the order of the Tahsildar granting lease to the petitioner has been given, I have the remedy to file the appeal under section 46, under rule 46, before the collector, which I have did.
No, but the collector has passed an order cancelling. See, against the order of cancellation, somebody can go and appeal.
No.
We are on the first order of cancellation.
No, my Lord. In the appeal, the collector can cancel the lease.
Where do you get that?
46, your Lordship will kindly see rule 46.
No. 46 is about against the order of sub-collector, you go to the Tahsildar.
Non-friend means to say that in appellate jurisdiction also the collector can cancel the
No, if the Tahsildar had passed an order, then in the jurisdiction he can do what the Tahsildar
Tahsildar has passed the order by settling the Sand Soirat in favor of the petitioner. That is the order.
Order pursuant to the order
of
the Honorable Court.
On your cancellation petition, who could have passed an order is question number 1.
Question, your Lordship is asking that question, my Lord. I have submitted before your Lordship, my Lord. I have come before the collector against settling the Sand Soirat in favor of the petitioner on the ground of the solvency certificate.
No, there are two parts, Mrs. Mahapatra. There are two parts. One is cancellation. First one is cancellation. Second one is granting lease in your favor.
Once
the lease was first cancelled,
the order
was granted in your favor.
Your Lordship,
1 minute.
The order granting lease.
1 minute.
Tahsildar's order, if it is appealed not to the collector, it is sub-collector.
I know. Also, there is a point here. So she did not have locus till such time this man's lease was cancelled.
That is what.
So first step had to be cancellation, then she gets locus, which is why she in fact gave an application for cancellation.
Locus, my Lord.
She would not have come into the picture unless his lease was cancelled.
My locus is, my Lord, from the inception, my Lord, the petitioner is not eligible.
But you have to actually get an order of cancellation. Only then your locus springs into action.
My locus standi, my Lord, I am submitting, my Lord.
It's not automatic. It's not automatic.
My locus standi is, my Lord, that I am the second bidder.
Only if his lease is cancelled, you become the second.
Because not cancelled, because he is his application is.
Let me read her own pleadings. Let me read her own pleadings in the representation. Under the circumstances,
his application I have come before your Lordship in a read petition, my Lord.
Undersigned being the third bidder. She writes herself that I am the third bidder in the representation.
That is admitted. She is the third bidder. That is admitted.
My lord, I have come before your lordship in a read
wants
jurisdiction.
to say that the bid of the petitioner is non-nest in the eye of law. I think
That is what she's trying to, but that doesn't become automatic. Somebody has to pass an order.
Because more particularly when the lease deed was executed and registered,
Exactly.
and he was allowed to operate for some day.
Correct,
I think.
correct. You can't just get rid of it. Yes.
My lord, that is my lord, that application is incompetent in view of the tender condition, my lord. I have come before your lordship in a read jurisdiction, my lord. A person will
Even in a jurisdiction, we are all bound by the rules.
My lord, if a person will give a solvency certificate, though it should be issued in favor of the trust, he has no solvency certificate at the time of application, my lord. Filing of the application, he has no solvency certificate at the time of filing of the application.
He did have. It only subsequently discovered that it should have been issued in the name of the trust.
My lord, the similar situation he has also applied in another Sans Serif that was cancelled after coming to know that.
No, right now let us deal with this Sans Serif. We don't know about others. We'll deal with each Sans Serif separately.
My lord, I am not saying so, my lord. I am saying, my lord, from the inception, his application should have been rejected on the ground that if he has filed a
saying that it is honest in the eye of law.
Right.
His bid.
All right.
That your lordship is to answer. May I pray your lordship to pass a
Lordship is to
judgment so
decide,
that
not
the
answer.
law can be settled on this score.
Correct. Yes, Mr. Monty.
Yes, my lords. My lords, if I may submit, my lords.
First,
His role is already over.
My lords, let me submit, my lords, what has happened in this case from my perspective, my lords.
Who has been cancelled already.
Yes.
My lords, if I may submit, my lords, I was the highest bidder, my lords.
All right.
What happened, my lords, on 16/4/2019, I was given the letter to deposit within 15 days.
Maybe, but you are not challenging. Here the question of selection of cancellation and selection of OP number 5.
Certainly, ma'am.
You have already been
missed the bus. Now you have missed the bus.
So you have no grievance against any of these, either against the petitioner or against.
No, my lords, my appeal is pending, my lords. My lords, pursuant to order of this honorable court, my lords. My lords, pursuant to order of this honorable court.
Both of them have joined together.
No, my lords, not at all, my lords. My lords, if I may submit, my lords, lordships may kindly appreciate, my lords. Pursuant to order of this honorable court, my lords, my appeal before the sub-collector is pending, my lords. In that, Ranjan Patnaik, who is the present petitioner, my lords, even after 6 dates has not appeared there, even though he is a party there. That apart, my lords, what happened, my lords, in this case, what my learned senior is taking recourse to, Rule 51(7), the qualifying words for that section is in case of breach of any condition of the lease deed, my lords. Here, my lords, giving a different solvency certificate is not a breach of the condition of the lease deed. Here, my lords, there is a breach of Rule 27(4), my lords. Your lordships may see Rule 27(4) for the time being, my lords. My lords, grant of quarry lease.
No. The lease deed condition itself is that it should be in accordance with the rules.
Yes, my lords. The lease deed, my lords. Lease deed never contains a condition that he has to submit the solvency certificate, my lords.
No.
After everything is over, my lords.
It contains a condition that he has to obey the rules.
My lords, Rule 51(1) says.
By reference, therefore, by reference to the rules, the lease deed requires that rules should be complied with.
My lords. My lords,
so it is a condition of the lease deed that the rules must be complied with.
Yes, my lords. My lords, lease deed comes second. Compliance of the Rule 27(4) comes first.
There's nothing like that. There's no sequential thing. It is always only the rules, please. It is always only the rules. There's no question of first lease deed, then rules, or first rules, then lease deed. There's nothing like that.
My lords, I'll explain that, my lords. My lords, the tender is brought to notice, my lords. When the Sairat is brought under hammer, my lords.
All of that happens only under the rules, please.
Yes, my lords, under the rules.
Everything takes place only under the rules.
Yes, my lord. That is why I'm requesting my lords to see Rule 27(4), my lords.
Yes.
Rule 27(4).
Yes.
Subject to other provisions of these rules, for settlement of quarry lease, the intending applicant may apply to the competent authority in a sealed cover for grant of quarry lease of such areas or areas in form M in triplicate accompanied by the following documents and particulars, namely, here important is sub rule 4, a solvency certificate or bank guarantee valid for a period of 18 months for an amount not less than the amount.
This doesn't say in his own name. This doesn't say in his own name. So you don't go down this route, you might get into trouble.
My lords, it says the applicant. The applicant has to submit a solvency. Now, my lords, may see for a moment.
Say in his own name. So let's not go down that route anyway. It is a condition of the lease that he must comply with the rules.
Yes, my lords.
So there's no question of running away from that.
That has to be.
If there is a violation of the rule, there is a breach of the lease.
My lords. My lords, then my lords may see rule 51(1), which says if he is taking sands in contravention of the rules, my lords. That says, my lords, whenever any person,
please. We are now in cancellation of the lease. I don't know why you are going somewhere else.
My lords, I'll tell something, my lords. My appeal before the sub-collector, which is pending, has a prayer for cancellation of his lease deed, my lords.
Again, so same problem. See, you're also only at 51(7) then.
My lords,
I am before the rules. You are a person who swears by the rules.
My lords, I am before the appellate authority.
No, why should you ignore only 51(7)?
So far as that appeal is concerned, it is pending before the appropriate, he will take a decision.
No, but if it's the same ground,
yes,
what decision will he take? It will be the same ground.
Same ground.
Your ground is a solvency certificate, it's not a correct one.
Ground.
My lords, my submission is it is not a fake, not a forged one. My case is based on Annexure 3, my lords, where the sub-collector under whose jurisdiction the solvency certificate was issued. If your lordships will see Annexure 3. My lords, Annexure 3, it was very clear that Guru Krupa Charitable Trust has some lands, and on the basis of that, the solvency certificate has to be issued to the trust. But my lords, this Tahsildar, not the present Tahsildar who is the competent authority in our case, my lords, but the Tahsildar who issued solvency certificate, my lords, purposefully issued it in the name of Ranjan Patnaik, so that Ranjan Patnaik can participate in this bid, my lords. My lords may see Annexure 3 and Annexure 4, my lords.
No, this is the main ground. We have seen it enough.
That is the main ground. The whole dispute is the property is in the name of trust and the certificate was issued in the name of one of the trustees.
Trustees. That is the entire case.
No, but what is the answer to 51(7)?
My lords, 51(7), my lords. 51(7), my lords, it says in case of breach of the conditions of lease deed, my lords. Here, my lords, we are in a stage before that. We are saying the lease.
We are not before and after. Listen, that is totally misconceived, that submission. There's nothing called a separate condition for the lease deed and separate for the rules. Nothing like that.
What your lordships are saying.
Even the lease deed itself is only under the rules. The lease deed itself is under the rules.
Absolute of rules.
Admittedly, my lord, there is a lease deed now, my lords. That, my lords, to that I'll bow down to your lordships contingent, my lords. What your lordships are submitting is correct, my lords. Rule 51(7), my lords. That part, that is different, my lord. But my
Tahsildar allowed him to rectify. He's already rectified.
No, my lord. Tahsildar never allowed him to rectify, my lord.
Anyway,
there is no order.
He says
no such order, my lord.
Submitted a solvency certificate in his own name.
No, my lord. All that happened after the order of the collector, my lords. Not prior to that.
See, the question is, if the procedure under 51(7) had been followed, he would have given the certificate which is given now.
My lords, that never happened, my lords, because then, my lords, he never had the solvency in his name.
What's the point in saying never happened? You see, that's the whole point. His argument is that he says that never happened, and therefore the whole thing is vitiated.
But my lords, then he never had the solvency certificate in his name, my lords. Subsequently, he purchased certain properties and got the solvency in his name, my lords.
He's given 60 days, which is why you're not reading that 51(7) carefully.
I understood, my lords. That part is there, my lords.
All right. The challenge in the present petition is to an order dated 24th March 2021 passed by the Collector Cuttack, cancelling the lease of the Sand Sairat source of Subhadrapur Moza and Katjodi River in favor of the present petitioner. The background facts are that an auction notice for grant of the aforementioned lease was published on 8 January 2018. Full stop. Clause 5 of the auction notice stated that the applicant should submit a solvency certificate from the revenue officer, which amount shall not be less than the royalty and additional charges fixed for the source. The applicant was also required to furnish details of the movable properties. Full stop. The auction notice itself referred to the Orissa Managed Mineral Concession Rules 2016, bracket OMC Rules 2016, and the requirement of having to fill up Form M thereunder. Paragraph. At this stage, it is necessary to refer to Rule 27 of the OMC Rules 2016, which refers to grant of quarry leases. Rule 27 bracket 4 states that the intending applicant should apply to the single court's competent authority in a sealed cover for grant of quarry lease for such area or areas in Form M in triplicate, accompanied by the documents mentioned at subclauses 1 to 4. Rule 27 bracket 4 bracket Roman small 4 refers to, open quotation, a solvency certificate or bank guarantee valid for a period of 18 months for an amount not less than the amount of additional charge offered and the royalty payable for the minimum guaranteed quantity for 1 whole year, and a list of immovable properties from the Revenue Authority. Unquote. The petitioner participated in the tender process and submitted his application along with a solvency certificate dated 7th December 2017, issued by the Tahsildar Narsinghpur. Paragraph. It transpired that the above solvency certificate was issued on the basis of an order passed by the sub-collector Atgad on 6th December 2017. That order referred to the lands standing in the name of single quotes Guru Krupa Charitable Trust, unquote, of which the present petitioner was a trustee. Full stop. The order specifically stated that the solvency certificate may be issued, open quotation, in favor of Guru Krupa Charitable Trust, chairman of village Kendupalli, instead of Ranjan Kumar Patnaik, son of late Turbacharan Bera of village Kendupalli, on production of original documents before you for verification, unquote. Paragraph. It transpired that despite the above order requiring the solvency certificate to be issued in the favor of the trust, it was in fact issued in favor of the petitioner. On 7/12/2017, and it is this solvency certificate that was enclosed with the petitioner's application. Paragraph. When the bids were opened, the highest bid was one Sukanti Sahu, and the petitioner was the second highest bidder. Opposite party number 5, Devi Datta Mohanty, was the third highest bidder. It is stated that Sukanti Sahu was issued a show cause notice dated 19th February 2018, stating that in respect of the Naranpur sand quarry under Baranga Tehsil, we had unauthorizedly excavated sand beyond the permissible limit. That is beyond the boundary of the Sairat, encroaching upon the Cuttack Sadar Tehsil area. It is stated that admitting the said conduct, Sukanti Sahu deposited rupees 10 lakhs out of the demand raised based on the joint inquiry conducted on 17th April 2018. Full stop. A subsequent notice was issued on 6 July 2018 asking Sukanti Sahu to deposit the residual default amount of rupees 32,18,750. A reminder was sent on 3rd April 2019 and 9th April 2019. Paragraph. On failure of a further demand was raised on 16th April 2019, noting that she was a defaulter regarding deposit of penalty for extraction of excess sand quantity. Full stop. With the failure of Sukanti Sahu to deposit the entire demand, a letter dated 7th May 2019 was issued to her by the Tahsildar Sadar Cuttack, cancelling the lease. Cancelling her selection as the highest bidder. Full stop. Paragraph. Since the petitioner was the second highest bidder, a letter dated 8th May 2019 was issued to him asking him to communicate his willingness to operate the sand Sairat at the rate of rupees 142 per cubic meter, which was the highest rate quoted by the highest bidder. On the same day, the petitioner is stated to have submitted his willingness. He was then asked by letter dated 9th May 2019 to execute a lease deed. The petitioner then deposited rupees 26,28,450, complied with the requirements of it. And complied with the requirements, it is stated that the environment clearance issued by the State Environment Impact Assessment Authority was also transferred in the name of the petitioner by a letter of the SCIA dated 31st May 2019. Paragraph. Sukanti Sahu filed writ petition civil 9023 of 2019 in this court, questioning the cancellation of a bid and selection of the present petitioner. Full stop. While issuing notice in the petition, this court directed by an order dated 15th May 2019, the status quo should be maintained by the parties. Full stop. On 15/10/2019, after hearing the present petitioner, who had filed an intervention petition in the said writ petition, this court vacated the interim order and disposed of the application filed by the present petitioner for that relief. Paragraph. The present petitioner thereafter filed writ petition civil 22660 of 2019 this court for a direction to the competent authority, that is the Tahsildar, Sadar, for execution of the lease deed. So thereafter, on 1st January 2020, a lease deed was executed in favor of the present petitioner in respect of the aforementioned Sand Sarat. Paragraph. A second petition was filed by Sukanti Sahu, being writ petition civil 951 of 2020, in which, while issuing notice, this court on 14th January 2020 stayed the operation of the lease deed executed in favor of the petitioner. The petitioner then applied for vacation of the stay. Full stop. On 11 January 2021, this court by detailed order vacated the interim order dated 14 January 2021, clarifying that the operation of the lease by the present petitioner would be subject to the final outcome of the said writ petition, that is writ petition civil 951 of 2020 and two other petitions pending, that is writ petition civil 9023 and 22660 of 2019. Full stop. On 22nd March 2021, the court noted that the order dated 7th May 2019 passed by the Tahsildar cancelling Sukanti Sahu's bid was an appealable order and accordingly relegated the petitioner, that is Sukanti Sahu, to the remedy of an appeal. It is stated that the appeal filed before the sub-collector as a result thereof is still pending. Full stop. On the same day, writ petition civil 9023 and of 2019 and 22660 of 2019 were disposed of with this court as having been rendered infructuous. Paragraph. Opposite party number 5, Devidatta Mohanty, filed writ petition civil 3326 of 2021 in this court, questioning the solvency certificate issued in favor of the present petitioner. Full stop. The said petition was disposed of with this court on 4th February 2021, directing the collector Cuttack to consider the representation of opposite party number 5. Full stop. While the matter was pending with the collector, opposite party number 5 filed writ petition civil 14241 of 2021, which came to be disposed of on 19th April 2021. In the said audit was noted that on 8th March 2021, the Tahsildar Narsinghpur had cancelled the solvency certificate produced by the present petitioner with his application, and that against the said cancellation order, an appeal had been filed before the collector. A direction was issued to the collector to also dispose of the representation of opposite party number 5 not later than 12th May 2021. Full stop. It appears that in the meanwhile, the petitioner was permitted to operate the San Sairat, and then it was stopped at the instance of the Tahsildar. Full stop. On 2nd March 2021, a letter was written by the Tahsildar to the sub-collector, Tahsildar Narsinghpur to the sub-collector Atagar, stating that the present petitioner was the chairman of Guru Krupa Charitable Trust, and referring to the fact that apart from the that the present petitioner had filed an application for issuing of a solvency certificate in his own name. But since he was chairman of the Guru Krupa Charitable Trust, the solvency certificate was issued in his name. It was stated therein that notice had been issued to the party and necessary steps had been taken for correction of the said certificate. Subsequently, another letter was issued by the Tahsildar on 8th. No, is sent by the Tahsildar on 8 March 2021 to the collector Cuttack, stating that the earlier solvency certificate issued in favor of the present petitioner stood cancelled, and instead certificate was asked to be issued in favor of the Guru Krupa Charitable Trust, chairman of village Kendupalli, unquote. Paragraph. Meanwhile, on 29 January 2021, the petitioner appears to have written to the Tahsildar Sadar Cuttack to substitute / exchange the solvency certificate given with his application. With another one in the value of rupees 4.6 crores, is it? Which had been issued on 27th January 2021. A copy of the said solvency certificate was attached. So, paragraph. On 24th April 2021, pursuant to the order passed with this court on 4th February 2021 and petition civil 336 of 2021, the representation of opposite party number 5 was taken up by the collector. Full stop. The collector noted in his order the allegation of opposite party number 5 that the solvency certificate submitted by the present petitioner, open quotation, has been forged many times earlier, unquote, and that the lease executed in favor of the present petitioner should be cancelled, and further that Devidatta Mohanty being the second bidder, the lease deed of the Subhadrapur Sand Sairat should be executed in his favor. Stop. The collector in the order dated 24th March 2021 noted that contrary to the order of the sub-collector dated 6th December 2017, where the solvency certificate had been asked to be issued in favor of the Guru Krupa Charitable Trust, chairman of village Kendupalli. It appeared that it was issued in favor of the present petitioner. It was accordingly concluded that the said solvency certificate, open quotation, has not been issued following the stipulated provisions of law, and hence utilization of the same by Shri Patnaik in auction of Sairat in the Katjodi River in Waza Subhadrapur is illegal, unquote. Accordingly, the said lease in favor of the present petitioner was cancelled. Paragraph. On 7th May 2021, while issuing notice in the present petition, it was directed that all actions taken in the meanwhile, pursuant to the impugned order, would be subject to the outcome of the writ petition. Paragraph. An intervention application has been filed, being IA number 11767 of 2021, by. Sorry, what is your intervention application? 7246.
My lords, 11956.
Okay, intervention application being 11956 of 2021 has been filed by Sukanti Sahu, seeking to intervene in the present proceedings. Paragraph. This court has heard the submissions of Mr. P.K. Ratha, learned counsel to petitioner, Ms. Deepali Mahapatra, learned counsel appearing for opposite party number 5, Mr. Soumya Ranjan Mohanty, learned counsel appearing for the intervener, Sukanti Sahu, and Mr. D.K. Mohanty, learned AG appearing for the state. Mr. Ratha pointed out that the procedure for cancellation of a lease is provided under Rule 51(7) of the OMC Rules 2016 and reads as under, reproduce that. He submits that in terms of Schedule 4 to the OMC rules, the competent authority in regard to minor minerals other than specified minor minerals in a quarry lease within village boundaries is the single quotes Tahsildar, unquote. His contention, therefore, is that in the present case, the lease deed could not have been cancelled by the collector, and therefore, on that short ground, the impugn order should be set aside. He further submits that in any event, the petitioner has rectified the defect of not furnishing a solvency certificate in his own name, but a solvency certificate which should have been issued in the name of the trust of which he was the chairperson. He pointed out that on 29 January 2021 itself, he had written to the Tahsildar for substituting the solvency certificate with another issued in his own name. And therefore, even this defect stood cured. Full stop. He submitted that without taking note of this, the collector has exceeded his jurisdiction in cancelling the lease. Thirdly, he submits that opposite party number 5, being the third highest bidder, did not have the locus standi to question the lease executed in favor of the petitioner. Full stop. Till such time the lease was actually cancelled, the question of opposite party number 5 having any right to ask for the lease to be executed in his favor did not arise. Full stop. As far as the intervener, Sukanti Sahu, is concerned, he submits that with his failing to pay the requisite penalty despite several opportunities, his bid already stood cancelled and there was no question of reviving it at this stage. Paragraph. Mr. Mohanty, learned AGA, pointed out that the application filed by the bid submitted by the petitioner was not accompanied by a solvency certificate which should have been issued, which was correctly issued in his name. Full stop. It transpired that it was wrongly issued in his name when in fact it should have been issued in the name of the trust. So therefore, the lease deed was liable to be cancelled on that ground. Stop. However, he was unable to dispute the legal proposition that the procedure for cancellation of the lease under Rule 51(7) of the OMC rules was perhaps not complied with in the present case. Paragraph. Ms. Deepali Mahapatra, learned counsel appearing for opposite party number 5, maintained that the bid submitted by the petitioner was ab initio void and could never have been accepted since it was not accompanied by a solvency certificate in the name of the petitioner. Full stop. the document that was enclosed as the solvency certificate was in fact not correctly issued and was contrary to the express orders of the sub-collector. So according to her, if the bid was ab initio illegal, then opposite party number 5 would automatically become the second highest bidder and would therefore have the locus standi to ask for the lease to be granted in his favor. Paragraph. Mr. Samiranjan Mohanty sought to advance the submission that Rule 51 bracket 7 only talks of open quotation breach of any condition of the lease deed, unquote. Whereas according to him, it was Rule 27, bracket 4 that was breached. And therefore, Rule 51 bracket 7 of the OMC rules may not strictly apply to the facts of the present case. Stop. Although he did not dispute that the appeal filed by the petitioner against the order of the Tahsildar dated, what is the date of the Tahsildar's order against which the sub-collector filed an appeal?
That is order dated 7/5/2019, my lords.
7/5/2019 of the Tahsildar is pending before the sub-collector. The ground for challenging the grant of the lease in favor of the petitioner was no different from the ground urged by opposite party.
I have one additional ground, that is Rule 59, my lords. One additional ground, that is Rule 59.
All right. You also refer to Rule 59, which states that any mining lease or quarry lease granted, renewed or acquired in contravention of the provisions of the Act or any rules or orders shall be void and of no effect. Paragraph. The above submissions have been considered. Full stop. It is plain that as far as Sukanti Sahu is concerned, despite adequate opportunities, she failed to deposit the penalty amount and therefore was declared a defaulter. And a letter dated 7th May 2019 was issued cancelling her bid. Full stop. The appeal filed by Sukanti Sahu against this order of the Tahsildar is stated to be pending before the sub-collector. Full stop. While this court is not called upon to express any view on the merits of that appeal, which will be decided in accordance with law, as far as the intervention by Sukanti Sahu in the present petition is concerned, it appears to be on a misconception that the requirement, that the expression, open quotation, breach of the condition, breach of any condition of the lease deed, unquote, is different from violation of the OMC rules 2016. Full stop. The lease deed itself is executed only in terms of the OMC rules 2016. Full stop. The form M, which is required to be filled by a bidder, is also prescribed only under the OMC rules 2016. Full stop. In other words, there would be no question of a lease deed prescribing conditions separate from the conditions prescribed under the OMC rules 2016. Full stop. Therefore, the requirement of fulfilling Rule 24 bracket 27 bracket 4 bracket Roman small 4 is very much a condition of the lease deed itself. So, which is why clause 5 of the auction notice incorporates this very requirement of furnishing a solvency certificate. Paragraph. Although the allegation on the basis of which opposite party number 5 submitted a representation seeking cancellation of the lease was that the solvency certificate was a fake document or a forged document, comma. The impugned order dated 24th March 2021 of the collector, Cuttack, renders no such finding. Full stop. Interestingly, the Tahsildar, which is that page where he says it's a genuine document? Mr. Rathan?
Page 77. Page 77, man.
Right. Interestingly, a letter has been issued on 2nd March 2021. The letter issued on 2nd March 2021 by the Tahsildar Narsinghpur to the sub-collector Attagad confirms that the certificate, solvency certificate issued was, open quotation, a genuine one, unquote. The fact of the matter is that solvency certificate, which was enclosed with the petitioner's application, the bid in the first place, ought to have been issued in the name of Gurukula Charitable Trust, Chairman, Village Kendupalli, and not in the name of the petitioner himself. Stop. It is possible that the confusion arose because the petitioner was in fact, you are in fact chairman of the trust.
Yes, sir. I am the chairman of the trust.
In fact, the chairman of the said trust. Full stop. This mistake does not appear to be a deliberate one and plainly a rectifiable one. Full stop. Therefore, by the letter dated 8 March 2021, the Tahsildar Narsinghpur confirmed to the collector Cuttack that the solvency certificate issued in the name of the present petitioner stood cancelled and was being issued in favor of the trust. That is Charitable Trust, Chairman of Village Kendupalli, unquote. The fact also remains that the petitioner has sought to substitute the said solvency certificate furnished by him with another issued in his own name on 27 January 2021. Paragraph. At this stage, it's necessary to note that under the OMC rules, the procedure for cancellation of a lease, in case of breach of any condition of the lease deed, is that the competent authority, that is the Tahsildar, has to give a notice of 60 days to the lessee, open quotation, to rectify the defects within the time specified, unquote. Full stop. Where the lessee fails to rectify the defects within the specified time, then the Tahsildar can cancel the lease and or levy a penalty not exceeding rupees 50,000. Paragraph. It is plain that in the present case, this procedure was overlooked. Full stop. There were two aspects of the matter. One was a representation by the opposite party number 5, which combined 2 or 3 prayers. One prayer was that the lease deed in favor of the present petitioner should be cancelled. Full stop. The second was that the lease deed thereafter should be executed in favor of opposite party number 5. Full stop. Since the representation had to be considered in accordance with law, the proper course would have been for the Tahsildar as a competent authority to address the first part of the prayer, that is cancellation of the lease in favor of the present petitioner. Stop. That would have then required the Tahsildar to adhere to the procedure set out in Rule 51, bracket 7 of the OMC rules. Stop. Till such time, the lease deed in favor of the petitioner was cancelled, the question of opposite party number 5 becoming the second highest bidder would not even arise. Stop. It must be recalled that opposite party number 5 was only the third bidder to begin with. Full stop. This nuance was probably lost sight of when the collector passed the impugned order dated 24th March 2021. Full stop. Under the OMC rules, the competent authority in terms of Schedule 4, who can cancel the lease deed, is the Tahsildar. No doubt, against an order of a Tahsildar, an appeal can lie to the collector.
No, it's sub-collector.
To the sub-collector. However, the competent authority's power under the OMC rules cannot be straightaway exercised by the collector in the first instance. Full stop. That being the legal position, in the present case, in the impugned order dated 24th March 2021, the collector could not have passed an order cancelling the lease in favor of the petitioner. Paragraph. Further, in terms of Rule 51, bracket 7, where there is a defect on account of breach of any condition of the lease, 60 days time has to be given to the leaseholder to cure the defect. Full stop. With the lease already having been executed in favor of the petitioner in the present case, the procedure for cancellation had undoubtedly to be only in accordance with Rule 51, bracket 7 of the OMC rules and not otherwise. If that procedure had strictly been followed and the 60-day time given to the petitioner, it is possible that he would have cured the defect within that time period. As it transpired, the petitioner on his own has in fact cured the defect and substituted the solvency certificate submitted by him in the first instance with another solvency certificate dated 27 January 2021, which is again issued in his own name. In that event, the question of cancellation of the lease would not even have arisen. This is yet another ground on which the court finds the impugned order dated 24th March 2021 to be unsustainable in law. Paragraph. For the aforementioned reasons, the court sets aside the impugned order of the collector Katak, and as a result, the lease in favor of the present petitioner would stand revived. As already clarified, the court has expressed no opinion on the merits of the pending appeal of the intervener, Sukanti Sahu, against the pending before the sub-collector, which will be decided in accordance with law. The writ petition is allowed in the above terms, but no order system.
Grateful to your lordships for giving such a patient hearing.
No.
Grateful, my lord. Grateful to your lordship.
Thank you.
Well, just one line, well, my appeal may be decided on its own merit.
No, I said that.
I will circulate this judgment to all the collectors because
this will honestly settle the issue regarding the cancellation of lease deed, my lord. There are many cases.
I think there is no reported judgment on this so far as the procedure to be adopted in case of cancellation of.
Right.
Yes, till date there was no such
provision, my lords. There is also another provision of Rule 46, my lords. There is no judgment of this honorable court, my lords, settling the position, my lords. With regards to appeal, my lords.
I know. At one stage, you were seriously considering
case of your Mr. Milan Kanungo, your lordship was going to render the judgment, but that was mutually
correct.
Now, my lords, it can come before your lordship, my lords.
Yes.
That's grateful, my lords.
All right, man.
weekly list.
Yes.